Okay, greetings everybody. My apologies for being late. As we get into this, StreamYard link is down below for anybody that wants to join. Please hit that like, share, and subscribe button. And remember, we were talking about a process that I'm hopefully going to be able to explain as I go along in correcting records as it relates to my own situation. There's our brother Russ. Greetings, Russ. My
Greetings,
apologies.
Wizard. I think we're going to be playing with some weak internet tonight, so I think I'll roll with the camera off and hang out as long as I can. I got some company around, but I'm here for the long haul.
All right, sounds good. We are going to go around 4 or 5 hours, and then we're going to take a break so I can get something to eat and then come back at it. So it's going to be a two-part here for today, and then whatever we don't finish today, we'll go ahead and hop back on tomorrow.
Sounds good to me.
Let me pull up my document. And what we're going to be discussing today, we're going to start out with the I've got information from Social Security Administration on trust. So let me get my document up here and get the links. Because I think we got through most all of the scriptural stuff now. And now we're going to start getting into the laws and codes. As we finished off yesterday, if you remember, we spoke about the Social Security card and how it operates. The front side is the debit side, which is the side we've been actually told to use and give that information out for, when people ask us for, medical situations, education, job, things like that. And we're actually not supposed to be doing that. What that does is places a liability on the public record. Whereas if we learn how to use the one on the back, it provides a private routing to extend credit. Okay. And that credit, most people have a job. And they go to work and they do the Social Security thing. They get their check and they take out Social Security and Federal Insurance Contributions Act, FICA. You see that on your check stubs. They take out a percentage for each one. And what that does is establishes at the Social Security Administration each quarter a credit, and it's called insurance credits. And that's what we're dealing with. So you are, in fact, establishing credits, but you're using the debit side, and nobody's ever instructing you or taught you how to use the private side. And that's what we're trying to learn. Everything I found in my life from point A to point B has some kind of routing. In that routing, just like you have on a regular roadway, you have a bunch of different driveways on each side of the road. And in this commercial system, what happens is when you've got information going along that route, if there's something in there that can reach out and grab information or grab that property or whatever, it's going to do so. And it's going to do so in a capacity of investment. They do the same thing that they do here on YouTube with your profiles and stuff. Same thing with Facebook and your profiles, any kind of social site. What they're doing is using those data elements for investment purposes and advertisement. Now, it doesn't directly affect you in those manners, but when it comes to things like court cases, then it does. And that's the same thing. What happens is there's information out there and somebody grabs a hold of it and says, okay, well, we're going to do this. And that's when they see that license plate on the back of your car, they know you've got a contract in place somewhere and they want a part of that contract. That's the same thing with the information going through these electronic routings. There's information out there, and as it's going along, people see the contract information, they want to grab it and try to invest in it. Okay. So if you don't know what's going on, things are going to happen, and some of it comes back to bite you. So what we've got here is Social Security Programs Operations Manual System. And it says information on trusts, including trusts established prior to January 1st, 2000, trusts established with the assets of third parties, and trusts not subject to Section 1613E of the Social Security Act. I'll put this in the comments section so everybody can do their research on this. This is straight from the Social Security Administration. It is a quite lengthy piece. We're not going to go over everything, but I do want to go over first introductions here. A trust is a legal arrangement. A trust is a legal arrangement. A trust is a legal arrangement. So everything to do with trust law is about legalities. It's about legal arrangements involving property and ownership interests. In relations to the Social Security Administration, they are the trustee in the interest of the obligations of the United States to make sure that the record is accurate. The benefactor, yourself, the one they give the card to, has a beneficial interest in it. And what happens is things are swapped. The Social Security Administration takes interest because for all of the funds that they deposit in a general fund, they get a matching from the federal government. So what happens is they take the money or property that belongs to the beneficiary, which is the record, and use it for their own purposes. Whereas if you learn how to use it, they can't take that property from you. You only give them the data elements pertinent to making an accurate record. You don't give them information that allows for contracting, such as on the SS5, you give an address in a national format, claiming that you're a resident of the state and a United States citizen, which is a contracting position. Okay. The contracting position, the arrangement, where are you arranged in the positioning? In that SS5, you have the ability to express that you're the benefactor, but nobody teaches you that. So the property held in trust may or may not be considered a resource for SSI purposes. Property held in trust may or may not be considered a resource for social SSI purposes. The general rules concerning resources apply when evaluating the resource status of property held in trust. So when you fill out that SS5, they've got all that property and they're holding it in trust, and you're a co-trustee. so they can place liability on you and tell you you have to appear in court and present documentation. If you don't present the documentation or you don't know what you're doing, it's malfeasance of trust, and they fine and penalize you for not operating as a trustee that has knowledge to do so. Of course not. Nobody's ever taught you. The general rules, and again, this is rules. It's not law. A trust is a legal arrangement. It is not a law. And there are general rules, not laws, concerning resources apply when the general rules concerning resources apply when evaluating the resource status of property held in trust. The resource status. Now, if they have a direct source, they would get it directly from the source. If you're the one that fills out the SS5 and gives them that information and it's entered into that system and it automatically says that's a resource and not the source, then they're going to go to you for the for the resource. You are the human resource. Okay. Applicability of policy instructions. Generally, these instructions apply to trusts not subject to the trust provisions in Section 1613E of the Social Security Act, which we evaluate using instructions in S through However, trusts that meet the requirements must also meet the requirements of this section. So these sections apply to all trusts. This section here applies to all trusts. Because even the ones in 1613E must follow these instructions. Use these instructions to evaluate the following types of trust. Trusts established prior to January 1st, 2000 that contain assets of the individual. That asset that I'm talking about is mom's statement of live birth at the hospital as an informant with her signature on it is the asset that finances everything. And it sits in possession of the state at the county level. That's what's recorded at the local county registrar. If the trust was established prior to January 1st, but no assets of the individual were transferred to the trust prior to January 1st, see section 01120.201. That's the very first one. And that's the part of 1613E. That's the beginning of 1613E. We'll open that up and go look at that here. Trusts that contain assets of third parties. This includes trusts that are established before January 1st, 2000 that contain assets of third parties, contain assets of the individual, which is the third party, to that birth. The doctor, the mom, and the third party. Established on or after January 1st, 2000 that contain only assets of third parties or the portion of commingled trust attributable to assets of third parties. They mention specifically right here in the very beginning, or the portion of a commingled trust. Remember, I've discussed Harvard Law Review, the right to follow trust property when confused or commingled. Confused or commingled. And this is what they're doing. They're commingling right at the very first, the fact that you were born with the fact that there is a birth registration. Now, the fact that you were born is a tangible event. and they create an intangible event known as birth and then register it tangibly on paper documentation. That is the commingling. Okay. Then it says other trusts not subject to section 16. Well, let me finish this one here. It says Indian Gaming Regulatory Act trusts established by the Indian tribes that meet a criteria in this one here. So that's talking about an actual commercial gaming trust. And that's those casinos. Those are trust establishments. Okay. You go in there and you use the chip, the house chips. That's trust property. That's why you exchange money, Federal Reserve notes, which is trust property of the United States, and make an equal exchange in like kind of more trust property that operates as currency in that house. Trust established on or after January 1st, 2000, to which the instructions do not apply. When it is determined that a special needs trust or a pooled trust exception is met, the trust must still be evaluated under the rules of that section. Special needs trust. What is a special needs trust? That would be the spendthrift trust that I'm talking about. The spendthrift trust, because the benefactor does not know how to spend, has never been taught how to spend, and does so thriftily, just like the prodigal son, taking his portion of the estate, going out and spending it unwisely and not knowing what he's doing. And then at the end of it, realizing when he wants to return to his state, to his estate, he has to indenture himself for 7 years to make the funds to go back home. Hold on just a second. I gotta close the door. Okay, I'm back. Sorry about that, folks. Got groceries coming. Special needs trust, and I looked this up. This is it's called the Mark Trust. I'll have to look it up again. I don't have the information at hand right now, but it's a pooled trust exception. What happens when you're born is that on that day, there are records for everybody that's born on that day, and they are separated out by their different jurisdictional territories, Federal Reserve jurisdictions. Okay. Everyone born on that day in one Federal Reserve jurisdiction gets assigned a certain Social Security number according to that placement. Those are all pooled together to establish a security by date. Okay. Case processing alert says trusts are often complex legal arrangements involving state law, tribal law, and legal principles whose evaluation may require input from agency counsel. Therefore, these instructions may only be sufficient for you to recognize that an issue is present that needs referral to your regional office for possible referral to the regional chief counsel. When in doubt, submit your question or issue via help. Glossary of terms. This glossary is intended for general reference and does not override or replace applicable state law with respect to matters such as establishment, operation, and termination. So it does not matter. It does not replace or override the process. Okay. State law respect to matters such as establishment, operation, and termination is a process from beginning, middle, and end. That's a process. And like I said, at enumeration at birth, there's the establishment of a burial trust. A discretionary trust is a trust in which the trustee has full discretion as to the time, purpose, and amount of all distributions. The trustee may pay all or none of the trust as he or she considers appropriate to or for the benefit of the trust beneficiary. The trust beneficiary has no control over the trust. Now, that is false. Trust law specifically states that the beneficiary is the true owner, and the beneficiary can dismiss the trustee. The beneficiary can step forward and settle the trust as the settlor. So I don't care who you are, this is disputable in law for the principle of the beneficiary being able to collapse a trust, because equity says that equity does not complete an imperfect gift. So you can't say, here, you're a beneficiary, here's a pile of shit for sustenance, and now you have to eat it. That's impossible. The trust beneficiary has no control over the trust. He most certainly does in all cases because of equity. Okay? A trust cannot operate against a beneficiary. And when it does, they can't say, well, the trust doesn't, the beneficiary has no control over the trust. He does. He can collapse the damn thing for its falseness. Fiduciary duty. A fiduciary is the obligation of the trustee in dealing with the trust property and income. Trust property and income. Income is the investment of trust property for profit, and that income is what you put out. It makes it profit and comes back. So you put the trust property out there as an investment. People invest in it. And then when it matures, those bonding papers mature and it comes back and people are satisfied there's a profit. A fiduciary is allowed to do so. He is even allowed to include some of his own property in that investment for income for himself. But he cannot dismiss the income for the beneficiary, and he cannot say the beneficiary invested. He invested it for purposes of the beneficiary. You cannot do it for any other purpose. You cannot invest trust property that belongs to a beneficiary that you are holding to make an income for yourself. Period. The trustee holds the property with due care solely for the benefit of the trustee. And like I said, if he wants to invest that trust property, he can do so for the benefit of the trustee. And he can take his percentage cut for that as doing so. But if he wants to provide income for himself, he can also attach his own property in that same investment. However, if the investment flops, is a loss, whatever, he has to maintain with due care the benefit of the trust beneficiary, so that if there's a loss, he has to replace it. The trustee owes duties of good faith and loyalty to exercise reasonable care and skill to preserve the trust property and make it productive and to account for it. A trustee is a fiduciary, but generally is not an agent of the trust beneficiary. So even though they're a trustee with fiduciaries, responsibilities and obligations, those obligations belong to the trust and the trust belongs to somebody else, and it has nothing to do with the trust beneficiary. Trust beneficiary is still supposed to receive the benefit, but is not an agent, and the beneficiary usually doesn't know these agents. Do you know the Social Security officer that gave you the card? Do you know who mailed it out? Do you know the judge? Do you know the officer that pulled you over alongside the road? These are all fiduciaries operating in trust, the public trust, and they're public servants, and we are beneficiaries of that trust. They are not generally an agent of the beneficiary. This is why they say the police have no obligation to protect you. Their only obligation is to protect the record. What do you think about that, Russ? Does that support the reason of protecting the record?
Absolutely, because there's the benefit. There's the beneficiary is the record.
Yes. The
So,
beneficiary is the record, and we are the benefactor to that record. Go ahead.
and that's why it's so important about that signature. We shouldn't be placing anything upon the record in any shape or form outside of those good works. Just my opinion.
Yep, absolutely. That paperwork shows the creation of a person and does nothing for the man that was born. It does not record that the man was discharged of his mother's waters and became a living soul. No one heralded that. No one made a superior record that would override and overrule that false trust. No one heralded the real trust that they have in our Father which art in heaven. And therefore, a legal trust which is false is created. So let's get back to the next one. It talks about the grantor trust. And before we do, we're going to take a look at this other one. Background for trust established with assets of an individual on or after. This is where they changed it on January 1st of 2001 or 2000 in accordance with the Foster Care Independence Act of 1999. All those hospitals are foundling hospitals. They create an immigration document and they steal the child, which is a person, not the heir, not the legacy, but the child. Child in this case is a legal term for the establishment of a person that is incompetent to manage financial affairs. On 12/14/99, the president signed into law the Foster Care Independence Act of 1999. Section 205 of this law provides generally that we consider trusts established with the assets of an individual or spouse as resources for supplemental security income eligibility purposes. So they're considering that documentation, the asset that mom signed, that documentation, as a resource because she was the spouse, not daddy. Okay. The law addresses when to consider earnings on or additions to trusts as income. The law also provides exceptions to the statutory rules in 1613E of the Social Security Act for counting trusts as resources and income. And that's exactly what they're doing with that Social Security. Like I said, they're taking that insurance credit and they're putting it in a general deposit and getting matching funds. The provisions of the law are effective for trusts established on or after 1/1/2000. For information on exceptions to statutory rules, see section da 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 da. That's where we're at. We're going to see the 203 part later on down here somewhere. Anyway, and then talks about the third party trusts. These provisions do not apply to trusts established solely with the assets of a third party. These provisions do not apply to trusts established solely with the assets of a third party. The asset is the signature. And that is what establishes trust and is solely based on that signature. That is mom's asset as a benefactor to that very same public trust. Okay? Do not apply to trust established solely with the asset of a third party. Everything has to do with that signature. That's how trusts are established in the legal system. It's a legal arrangement, and you arrange yourself by putting your name on that document in signature form as one of the trustees. Grantor. This is what I'm talking about right here. Grantor, sometimes also called a settlor or trustor, is the person who provides property to the trust principal or corpus, the body. Okay, so if you're the one providing the data elements to the record, which is the trust body or trust principal, then you are the settlor or trustor, also known as the benefactor. So I'm going to show you real quick. When you punch into your search engine beneficiary or benefactor versus beneficiary, it will clarify the fact that you are not the beneficiary. And that says, and this is Benefactors, Washington State University, and we can read it all the way through. You can go down and look at the next question and show, and all of these will show the same thing. The benefactor gives benefits. Beneficiaries receive them. So if the benefactor gives the benefits, is that not the same thing as the grantor who granted the gift to the beneficiary? Who receives money from a benefactor? A beneficiary is a person or organization that has been named to receive property belonging to another in the event of their death. So if the beneficiary is receiving information, that information is intangible property that belongs to you, and I'm urging you to keep your fucking mouth shut. Quit doing that. Often the benefits received are financial ones related to financial accounts owned by the benefactor. Like I said, trust law says the beneficiary is deemed to be the true owner because the gifts are coming from the benefactor, who is the one whose name the interests sit in. What is considered a benefactor? Remember, I said I'm not a who, I am a what. I am a verb. I am the benefactor that gives. Someone or something that provides help or an advantage. What is considered a benefactor? Someone or something that provides help or an advantage. One that confers a benefit. A benefactor of humankind, especially. A person who makes a gift or bequest. His endowments. His endowments. Greetings, Chris. How you doing today, brother?
Oh, good enough. Can you hear me?
You betcha.
Oh, good. Took me a minute to get my tablet booted up. I had one of those faulty cords plugged into it, and it wasn't charging. So you know how that goes.
Yeah,
Sure.
I got a companion that has a problem with those. She'll kink the end up. She'll kink the end up on them.
I put a little dab of super glue on mine now, so helps keep it in place.
So
I found it very interesting. I'm a big advocate for going out and talking with the public officials and the trustees about what they might do better. And I went down to the Social Security Administration, got one of these, and started a conversation with a certain young lady down there. Not revealing everything I think I know, but revealing certain things, because I know that they're recording these things and taking note when we go. Right. So, I expressed to her certain understandings as, I understand myself to be the beneficiary of that trust, and I have the capacity to collapse it, just like you had been talking about. Right. And and also to control it. So we ended up coming to an agreement that I get to go talk to a magistrate trustee by filling out their form, and then I can re-express the trust in the way that I want to, since it had been created by a guardian before I had attained the age of maturity, as it were.
absolutely, and that's
Right.
the way it's structured.
Right. So they just have a very simple form. I have it in the office here somewhere. You fill out like 4 lines on the top of the form, and then they'll set you up with an appointment to see a magistrate. And you can tell the magistrate what you think you know. And that's what we came up with, was that the remedy for my situation of wanting to collapse the trust and operate through the trust that which I created, I'm the trustee of. I expressed that I was going to operate through that, and then that we needed to talk to a magistrate to settle up the account, and they were all agreeable to what I presented to them. And
Awesome.
it's based on some a lot of research that I've done personally, as well as what benefit I've derived from learning through your venue as well, has brought me to the point where I feel confident to go and talk to that trustee and let him know that I understand how the trust is to be structured, and what's to be done. Anyway, so just wanted to kind of report to you on that, that I'm doing my best to take action and participate with your venue here, so we can show the other folks that it's not an impossible task to amend things.
And I appreciate that so much, brother. That's the kind of support that I'm truly looking for. I give kudos, and I want to do that now. Thanks, Freedom Fighter, Miranda, Channel 3, Amsel Medic, Vic Cunningham, all you folks out there, Russ and Chris here. I appreciate all your support. I appreciate the viewing of the videos. I appreciate the monetary support through the PayPal links. They're in the detail section for anybody who wants to share some love. But the greatest support we can give each other is in our actions. So I appreciate that, brother. Appreciate it.
Very good. I'll let you get back to what you're going on, because we really appreciate it. The folks that are connected with my crew, we're listening to very closely to all your research and how you're putting your venue together on the Heckle bus here, and we feel like very special people on the special
Awesome.
bus.
Appreciate it. You are.
Very good.
All right. So let's take a look at this again. Back at the benefactor, what it means to be beneficiary, what are the different types of beneficiaries, what happens if a benefactor of a will dies. See, as it said earlier, they're supposed to, often the benefits received are financial ones. Receive property belonging to another in the event of their death. Okay, so the record is the beneficiary, and that's the one that receives the property after the death. Why are you giving them property before your death? Why are you giving them data elements before your death? That's the problem with that Social Security card. As I understand it, we're supposed to be using the number on the back to privately route for the extension of credit. And that way, the property comes to us and it doesn't get sat with the Social Security Administration. And then they take an interest in it of holding property that doesn't belong to them because the decedent hasn't passed away yet. So if the decedent gets in a car accident with his property and it's registered with the state and they're holding that property title, now they have an interest to make sure that that property is refurbished for the benefactor. But nobody's coming forth as the benefactor. Nobody's recognizing a benefactor. Everybody's going to the record. Everybody wants to enter documents into the court and go to that record. That is the false trust. The true, pure trust. Every word of God is pure. It is a shield unto he who put their trust in him. This legal trust is false. So let's go back to the glossary of definitions here in regards to the trust on the first page. So a grantor, sometimes also called a settlor or a trustor. And I will insert here benefactor is the person who provides property to the trust principal or corpus, the body, the documentation. The grantor must be the owner of or have legal right to the property or be otherwise qualified to transfer the property into the trust. Like I said, I fear not, for I have been redeemed. He has called me by thy name. I am his. He is my trust. And if I'm his property and I'm using this automobile and it's already paid for and I owe nobody else any interest on it, then it is my property and it is put in that trust. I don't need to put a legal trust down for it. In trust law, express trust is a valid trust. You can do it orally, verbally, literally, either, any, all, or none. If you do none, if you do not express the trust, their public trust will treat you as a criminal. That was my problem throughout my life. I wasn't realizing the real trust, and I was placating to the documentation and everything in my life. And that's a false trust. A person may be a grantor, even if an agent of another person, legally empowered to act on the first person's behalf. A legal guardian, representative payee for Title II or Title, 16 benefits. Person acting under a power of attorney or conservator. It's all about conservation. I talk about that conservation easement around each property with an address. You are the conservator within that conservation easement. Treating you as the conservator. As if though you've got powers of attorney and don't even have a license to practice law. This placates so much idiocy. Once I started researching it and realizing how things connect, it's just astounding. Establishes the trust with funds or property that belong to the first person. So mom, as a grantor, established a trust with a document, which is her property, the ink that she put on that paper in a signature, that is her property. That signature is her property. That document belongs to the first person. It's got your name in it, and it tells you who the grantor was. It tells you the name of 2 co-trustees as well. It's a public document. Therefore, those 2 co-trustees in public service are operating a public trust, and they took the property and commingled it with theirs. The person funding the trust is the grantor, even in situations where the trust agreement refers to a person legally empowered to act on the first person's behalf as the grantor. So if it's based on a signature, where does the funds come from? Those are the fines, fees, and penalties that they use. And on the other side of the court, I don't know if it's the clerk or the programming that does it now, but somebody converts that last name to an obligor or to a firm name and the social security number to an obligor as an investment, and then demands that you pay the fines, fees, and penalties. That is the funding. Where more than one person provides property to the trust, there may be multiple grantors. In order for you to get that funds, you have to get those funds from the government. The government is funding these trusts, and then they turn around and get you to fund them as investments as a trustee for the beneficiary. Like I explained earlier, the trustee is allowed to invest trust property for the interest of the beneficiary. And they're operating you as the trustee and investing those funds as if though you're an investor and investing in the beneficiary, which is the record. Grantor trust is first party or self-funded trust. Till its collapse. All of those credits are going to be reverted back to the first party of the trust, me. And that's going to be held in trust, in a valid trust with the proper trust office, the judicial office, tied directly to the general ledger, showing that they are separate funds and cannot be commingled anymore. A grantor, also called a first-party trust or self-funded trust, is a trust in which the grantor of the trust is also the sole beneficiary of the trust. Read that again. A grantor trust, also called a first-party trust or self-funded trust, is a trust in which the grantor of the trust is also the sole beneficiary of the trust. Does that make sense, guys? Sole beneficiary of the trust.
It certainly does to me.
Keith, could you explain the differences between beneficiary, sole beneficiary, and benefactor to us here? That was a question that came up with our crew here just now.
Okay, sole beneficiary. Remember, that's the term soul, and in sound. If you have a sound mind, you can listen to the words of a sound mind speaking. So when we say a sole beneficiary, I take it as I am a living soul and I am the beneficiary, and that is my sole beneficiary arrangement. That is my position, my expression of the trust. You do not have to take the terms that they've written in the legal course and apply them to yourself. Again, the importance of etymology is learning the origins come from the intent. They come from the spiritual intent. So what you have to do in expressing the trust is make some clarifications. So when they talk about the sole beneficiary, they're talking about the individual. Again, a legal definition because it has its exclusive jurisdiction. Whereas my presentment in sole beneficiary is the living soul. And we are all beneficiaries in that aspect of the pure trust, as I've spoken of. We're not talking about legal trust in that case, but in that case of a legal trust, the sole beneficiary is the individual, the one, and it means no one else. So it's a limitation and exclusion of everything but myself. Whereas myself expressing the pure trust as a sole beneficiary is inclusive of every other living soul. I hope that makes sense.
Yeah, sure does.
Awesome. Awesome.
We appreciate it. Yeah.
Okay, the next one, I'm going to skip down. Like I said, I put that link in the chat section.
I think it's very important that we hit these points for the folks, because we would imagine that there'll be those who, actually go and attempt to do the things that we're doing now, and that they need to have the capacity to educate the trustees and what they might not have been known or trained to know.
Absolutely, absolutely. That's why I do this, because like I said, when I did my research, I've only been at this for 7 years, and I've got a massive amount of information that's available that I comprehend completely. And I think I can teach others in a much more basic and simple way what's going on. And so I'm doing this now, and as time goes on, it will get simpler. People will catch on, and it will be better, people will be better able to apply what they need to in their life. So,
well, I can tell you that the education that's gotten by the modern magistrates and chancery is insufficient, and I think that's intentional. I've sat in private counsel with them, and they've found themselves fascinated by the things that I bring up, and and then of course they go and they do the research, and I think that on a very small level it's actually really appreciated by them, even though they may not be expressive of it.
Absolutely, and that's why it's important to read this stuff on their sites. This is where it comes from, and when they find out it comes from their own information, then they have to become knowledgeable about it. They cannot dismiss it as just, oh, that's babble, you don't know what you're talking about. No, people ask me, where'd you get your information? The internet? Yes, I most certainly did. So anyway,
right, and then we can't we can't dismiss the importance of studying the great works of Henry R. Gibson and others, that have written such nice texts on equity and trusts that that's readily available.
Yeah, if you want to get into the equity side rather than the plain writing and etymology side and stuff, construction of the trust here as legal definitions, check out Rourke, Gibson, all of them. There's a plethora of them. But if you do
that's what the modern law schools tend to be leaving out of the education of the chancellery these days. And so when they hear it, they just they eat it up, because they're like, it's just something that they weren't exposed to. And I think we need to shed a light on those previous writers, who've really been, like a lighthouse in the dark ocean.
Well, it's the cornerstone of law. It's
right.
The cornerstone of law, period. So let's continue on. We've got Medicaid trust or Medicaid qualifying trust. Remember I told you through the Centers for Medicare and Medicaid Services, once somebody is born, they're automatically qualified. It's an automatic qualification for Medicaid. So we're seeing Medicaid trust or Medicaid qualifying trust when you're born. That's what's established. And that's for SSI treatment of Medicaid trust exceptions. Okay. The pooled trust is a trust that is established and managed by an organization that contains and pools the assets of multiple individuals in separate accounts for investment and management purposes. That's Social Security. That is the pooled trust. And that is why they ask for your signature, because they want to securitize the documentation as investments. Those are bonded papers. Every paper has a bonded weight. And a signature on it gives it value according to the terms and conditions placed. This section contains information on reviewing third-party pooled trusts. For information on pooled trusts in which the individual account is funded with the beneficiary's own assets. Again, what we read earlier. You're funding it with your own assets, and then they're taking it out and charging you fines, fees, and penalties and taking those assets, even though you're the one funding it. You're the benefactor because they're treating you as a trustee. Okay? Even though they know that the benefactor is the one that gives to the trust, or should know, then they shouldn't be taking that property once it's given, even if it is a decedent estate. Residual beneficiary. This is the one here that we're working on. A residual beneficiary, also called a contingent beneficiary or remainder man, is not a current beneficiary of a trust, but he or she will receive the residual benefit of the trust contingent upon the occurrence of a specific event, such as the death of the primary beneficiary. And again, the primary beneficiary is the record. You are the second or residual beneficiary because they used a legal name and not a given name. So the given name and that record is the residual beneficiary because it didn't come forth as the primary beneficiary. So now you can state that as a specific event, collapse that trust, and now you are the remainder man. You get what remains. Okay. Russ, what do you think? You with us?
Yes, I'm with you. I was just sitting here explaining some of this. My mother happens to be with me listening, so
That's why they call the corpus after the soul transcends the mortal coil. They call that the remains, right?
Yep. It's the remainder, and that's
Right.
what we're
Which
looking
then
at.
they put in the box of a trust, and with the headstone, like you were tying that understanding in.
Yep, and that's the capitalization of the legal name engraved on a stone, and usually it's not a white stone, and it sits on a flat stone that's called a ledger. So ledger to
Right,
ledger.
which in a sense, and if you see how they set up a lot of these cemeteries, it is very much like a battery. I don't know if you've seen how they do copper and zinc to make an earth battery. Well, they're doing the same thing in a cemetery, setting it up in a like a battery with the positive negatives connected and everything, and that's what's generating the power for the underworld to keep the empirical plan going.
Yep, and that's like I mentioned yesterday. I don't need a burial trust. I don't need a burial plot. That's the legal thing. Okay, as a natural creature, I would prefer that Mother Nature take me back, and not in a way that man perceives that it should be, but in the actual way that Mother Nature takes back its creatures. You see,
Well, this is also ties. It also ties into, if you look at different belief systems, and religious spiritual traditions. Some traditions they bury the dead, and others they burn them to ash, and then put the spread the ash of the crema from the crematorium on the holy land of that person's faith, right? There's
Yep.
different ways of doing that, but I was saying, that this whole idea of bringing the dead back to life, right? I think there's something to that, because the soul that's attached too much to the body remains attached to the body, and this is why they say, well, there's ghosts inside the cemetery and whatnot. It's because these souls that are too much attached to the mortal coil and not to the spirit of Christ and the higher world, as it were.
Well, yeah, and much like the wolves, the native Indians, or natives, I guess I don't like calling them Indians, but natives, back in the day when they migrated north and south, it seems kind of cruel and stuff, but they're ancient ones, they're older ones that couldn't sojourn anymore, that couldn't make the trip.
Right.
They would oftentimes just leave them behind and let them die alone, and it was a matter of acceptance. They knew it was a matter of nature, and they are the ones that were glad to buy property when the United States wanted to sell it, because their premise is that you can't buy property. But hey, if you want to sell it to us, sure, because the reality of it is that we do not own the land owns us. Where we came from is where we're going right back to dust.
Well, then also brings us back to that imperial definition of land, and when they were expressing to the minions to go and conquer new lands, I think that they were more so speaking of the people and their bodies and their minds more than the soil of the earth, right?
Yep.
And I want to, very, very successful in that.
Yes, and that's why we take a look at these legal terms and stuff and tear them down for what they are. And I do appreciate that question, whoever brought it up in your group there, about the sole beneficiary. That's an important aspect when they're talking about sole beneficiary in the legal term. It's the individual, meaning one, excluding all others. Whereas the sole beneficiary in my express trust, it includes every last one of us. It is inclusive of everybody. So real quick, right. I want to take a moment.
I can show you later. I don't have it immediately available to me, but in my own private express trust that I created for the house here, I took the soles of the feet in red, in a dark red, and in ink, and I inked them on papyrus paper to show that, this basically the sole of the foot.
Right, and that proves standing.
Right, that I have standing as the trustee to over that express trust. Right.
Right, and the signature expresses authority. The soul.
Right, like they put the footprints on. They put the footprints on the birth paperwork, but those footprints are in black. Right, when they take those, the footprints for the original birth record at the hospital.
Yes.
Right,
and that is the memorial birth certificate. See, many people, when they order the certificate from the state, they get a certificate from the state, but it's not the one with the footprints on it. You want the memorial birth certificate as a matter of, you should get that from the hospital. They offer it at the hospital nowadays. When a child is born, they offer you a memorial birth certificate with the footprints on it.
Yeah, and then those are footprints from your infancy, so that we can take control of that record once we have it, once we have a copy of it. They won't give us any original, of course, but
I personally
No, but you,
that's my understanding of it anyway.
I personally haven't had any luck on obtaining that particular document there.
the one with the footprints?
Correct.
It's
Go to the
yeah,
hospital
yeah.
you were
I think you
born.
have to speak to it knowledgeably and you know, like make a claim like at least 3 times. Like
They
they
used,
really don't want to let that stuff go.
yeah,
Yeah,
they
you got to go to
used
the
a,
hospital where you were born and speak to them and let them know you're trying to put your legacy documents together and you need a memorial birth certificate with the footprints on it. And they should have no problem. That's at the
memorial
hospital.
birth certificate. Okay, because they told
Right.
me, and when I spoke about that, they told me it was something basically. I forget the term they actually used, but it was something like glamorous.
It's probably
Oh, yeah,
better not to call them on the phone about it and send them some written correspondence.
Probably
absolutely.
done.
Yeah, that's because on the phone they're actually trained by Jesuit canon law attorneys not to speak to certain things that even if they do have knowledge of it.
Yep.
Right.
Yep. I would believe that.
Yeah.
Okay. Now the next thing, I've got another one here is here. Social Security spotlight on trusts. Revocable versus irrevocable. Now this goes to the decedent again and the property being transferred at death. Because when you look at the revocable and irrevocable, they're obviously different terms, counterintuitive to each other. And what we have is, as of January 1st, 2000, the Supplemental Security Income Law and Trusts changed. That's what we just read. That's the Foster Care Act of 1999. It says, what is a trust? A trust is a legal arrangement regulated by state law in which one party holds property for the benefit of another. So it's a trust is a legal arrangement regulated by state law. Cash or other liquid assets, real or personal property that could be turned into cash. This is your real, your tangible and intangible property. That's your thoughts and your belongings.
So the intangible would be the intellectual
The
property.
writing down of intangible things.
Mm-hmm.
How does a trust affect my SSI benefits? We're not going to worry about that. What we're going to look at is this. In the case of a revocable trust, the whole trust is your resource.
Gonna jump in real
In the
quick,
case,
Keith.
go ahead.
What was that you called that document with the footprints?
Memorial birth certificate.
Okay, thank you.
As in memoriam, to make a memorial
Yep.
of the on the record.
In the case of irrevocable trust, if there are any circumstances under which payment could be made to you or for your benefit, the portion of the trust from which payment could be made is your resource. Okay. When it comes to irrevocable and revocable trusts, let's do revocable versus irrevocable. A revocable trust can be changed at any time by the grantor during their lifetime, as long as they are competent. This is the whole issue about competency test in the courts. When they ask or suggest that you be put up for a competency test, ask them if it's a competency test to be the grantor of the trust, or if it's a literacy competency test to be able to know the English language. Those are two different competencies. So the basic thing about an irrevocable trust is that trusts usually can't be changed without a court order or the approval of all the trust beneficiaries. Why is that? Because a revocable trust is operating during the lifetime of the grantor. Once the grantor dies and becomes intestate decedent, now it's an irrevocable trust. That living will, the statement of the will that has to be executed for the beneficiaries after the grantor dies. So while the grantor is alive, it is a revocable trust and can be revoked. As Chris was saying, he wants to go before the administrative law judge and let him know he's going to change the trust. That's a revocable trust, and you can do that. The irrevocable trust is the one established by mom and dad after they passed. Now, that irrevocable trust is in operation of reason and logic. Fundamental basics of inheritance law is that you have the right to the inheritance of your parents without interference.
Keith, I was just going to add that before I go before that magistrate, Social Security trustee, I'm going to be going to the courthouse in Miami and asking a probate judge to recognize the removal of the legal disabilities of nonage, right?
Yep.
And recognize that I've attained the age of majority and the capacity, at least, to control the securities of it within the minor account, that show and show my legal and mental competency to be able to collapse that trust and manage my own trust. So that's they have that process in other states. Florida, it's where there's a lot of retirees, it's more common in those courts. But every state has a process for removal of the disabilities of the legal nonage, which means that he has yet to attain the age of majority or maturity, and manage the securities in the minor account competently. I just wanted to kind of add that point in my own process. And so once I have a court order that they've removed those legal disabilities, that's something that I can give to the Social Security magistrate to let him know that I've been found competent to do such things. Otherwise, he might just thumb his nose at me.
Yep, absolutely. And Paul puts down in the comment section, isn't the trustee the one that gave one any forms of documentation without a proper correction of the record? Yes. And it doesn't even have to do with proper correction of the record. The trustee is the one that gives you the documentation. Anyone that gives you an instrument of government is a trustee. They are performing public service, then they are a trustee. That nurse at the local hospital, I don't care what her degree is, I don't care what kind of nurse she is, she's performing the functions of a public office by putting signatures on public documentation. He is the trustee. No one else needs to be signing those documents except the trustees. Those trustees are contractors contracting with each other. By you signing a document, you act in the same capacity, performing the function of a public office by signing a document. That one thing alone is the performance of a function of public office on public documentation. Signing your name on a private letter is not the performance of a function of public office. It is your own affairs. You can sign it. You can put a thumbprint on it. You can put a little happy face on it. Whatever. This is the same in law. It is your mark. But this particular venue, it's private, so it has no legal effect. Everything in
I
public.
wanted to add to that there, Keith, if you wouldn't mind. Now I filled out the form to be able to see the magistrate there for the Social Security, and when I signed that form, I signed it in the capacity of the subrogee. Right.
There you go.
Right, and I signed it last name first, first name last, because the last shall be first and the first should be last in that maxim.
Yep.
And that's, and I'm acting, Colin is the authorized representative or party agent, or and then so I did that, and then last name first, first name last, and then comma subrogee without prejudice. This is how I endorsed that form that caused them to recognize that I need to talk to a trustee, but they have yet to set up an appointment, but that's in process. So awesome. I just kind of wanted to add that, and if you had anything to add to capacity and how if anyone else is going to do these things, they maybe need to know why we would do such things, and without prejudice, what that also means as far as that you intend to not have any rights that you would have in the contract. You'd like to retain those rights under UCC.
Right. Prejudice means prejudicial. Prejudice, prejudicial. So prejudicial, pre-monetary value is the rights. The rights that you retain, still retained, and therefore if any value extends from them, then you can make judicial determinations within the trust.
And, so those who are signing UCC 1-308, I would encourage you to go and read the Uniform Commercial Code at UCC 1-308 and read that language, because nowhere does it say that we should write UCC 1-308. It says that these specific words are sufficient. Meaning, we're not. If you write the code there, that's not what is instructed. It says, the words without prejudice, without recourse are sufficient, indicating that that's how our endorsement should be reading.
Correct.
I've seen a lot of errors on people's documents where they attempt to reserve or retain their rights, and they write UCC 1-308, presuming that that's going to be comprehended when that's not, people don't necessarily know UCC.
And that's why I say when I did those 11 citations, UCC 1-308, that was like 10 years ago, almost 9, 10, 11 years ago, over a stretch of 3 years. And at that time, that's what I comprehended. But again, like our brother Chris says, that's the true essence of it, is the words, not the code itself, but the words. And so if they feel need to drag me into those courts on those citations, I can now firmly assert my position, like he said, last name first and first name last, as the subrogee with a prejudicial, predetermined, or preset principle in nature that is a variance from their fundamental, or is fundamentally different from their legal standards. And that's what we're doing, is correcting that record according to the legal standards.
Right, and that subrogee position, that's a hat that no one's wearing, because a cap is like I have a hat on. This is my cap, right, and it represents that a certain duty. Like when you'll see a state policeman wearing a cap, or so many different professions, people wear caps. Those are capacities. And so, in any contract, I'm looking at what capacity am I coming in, and what hat am I needing to wear in order to come in and deal with this contractual situation, right? So that would be, that's not necessarily a beneficiary signature. That's a signature of a subrogee specifically.
Yep. And we're going to take a look at some U.S. codes now in relations to correcting the records. As I say, we're entering data elements into the record when we're not supposed to be. And it says whoever commits an offense against the United States or aids, abets, counsels, commands, induces, or procures its commission is punishable as a principal. So every last one of these people in public service with contracts doing such is punishable as a principal, even if they are just a mere public servant. Whoever willfully causes an act to be done, which, if directly performed by him or another, would be an offense against the United States, is punishable as a principal. So when the judge sits there and says that you have to sign this document, that is a punishable offense because I do not have to sign a goddamn thing. Neither do you. Never. Whoever willfully causes an act to be done, which if he directly performed by him or another, would be an offense against the United States. Signing your name to a document is not an offense. But having somebody else tell you that you have to, otherwise you're going to go to jail, is an offense. Because when you're signing that document, again, it's signing in the capacity of a trustee, unless you can otherwise qualify it as the benefactor. If you are not knowing this and they are using that against you because you don't know, that is an offense, as if though they signed the paper themselves in your name. That's forgery. That's counterfeit. That's fraud.
That's also tampering with a witness.
Yes, we're going to go
What
over
is that?
those.
What is that particular fraud violation? Where's that to be found? That's an
That's
18
that's
USC
18
violation.
18
Yep.
USC 2. 18
18
USC 2.
USC 2.
Yes. Then we have
All
18
right.
US Code 6. Go ahead.
Maybe we can put that. I'm gonna try to find that. Put that in the chat. 18 USC 2. Oh, there it is.
And as we look at this, US Code 6, department and agency defined. As used in this title, the term department means one of the executive departments enumerated in Section 1 of Title 5, unless the context shows that such term was intended to describe the executive, legislative, or judicial branches of the government. The term agency includes any department, independent establishment, commission, administration, authority, board, or bureau of the United States, or any corporation in which the United States has a proprietary interest, unless the context shows that such term was intended to be used in a more limited sense. Not found. Section 1 of Title 5. The link shows not found. So this is in my research shows that they are currently going through a revision of that particular section of the title. But what they're referring to there is 5 USC 301, departmental regulations, under which they have the Plain Writing Act, the minimum birth registration requirements, and that code tells us that these laws are applicable to the Department of Defense. The next one, 18 U.S. Code 287, false, fictitious, or fraudulent claims. Whoever makes or presents to any person or officer in civil, military, or naval service of the United States, or to any department or agency thereof, any claim upon or against the United States, or any department or agency thereof, knowing such claim to be false, fictitious, or fraudulent, shall be imprisoned not more than 5 years, and shall be subject to a fine in the amount provided in this title. Remember yesterday when we were reviewing the administration and the dummy corporation setup, where they are the ones that are making a claim as a debt owed to the United States, and they're doing it in the interest of the state on behalf of the United States without mentioning the United States, by making a claim against the United States citizen known to be a resident. And that's the fraud. Whoever makes or presents to any person or officer in the civil, military, or naval service of the United States, you are considered to be a civilian by carrying that identification. That makes you subject to this law for giving them false information. You are not, in fact, a resident. You are not, in fact, a federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board. It was never done. It never happened. That all the data information you're entering into that record, you are not supposed to be doing so, because you are not the officer. You are not the agent of the agency. You are not a corporation.
I guess they found it not to be very expedient to explain that to the majority.
Oh yeah, this is stuff that they don't teach in the general education, which is pertinent to understanding what you need to what you can do in life in regards to that legal entity when you become an adult. If no one's teaching us this and we have to learn it on our own, how many years is it taking us to learn it? I'm 57 years old still learning this shit. I should have known this stuff before I left the house. So the next one, 18 USC 1001, statements or entries generally. Not specifically or particularly, but generally. That's the general public. That's when mom goes to the hospital to give birth, to have a baby. Except as otherwise provided in this section, whoever, in any matter within the jurisdiction of the executive, legislative, or judicial branch of the government of the United States, knowingly and willfully falsifies, conceals, or covers up by any trick, scheme, or device a mere material fact, makes any materially false, fictitious, or fraudulent statement or representation. The hospital claims that mom is an informant. What does that term informant do? When mom makes that statement and signs that document as an informant, it creates an investment. It creates an investigation. That's false. Makes or uses any false writing or document, knowing the same to contain any materially false, fictitious, or fraudulent statement or entry.
She joined the Inquisition by becoming an informant.
Right, and she made a statement that was then entered that is false.
Right.
And this is the false entry into their records. It does not belong there.
Yeah.
That is the reason for collapsing that trust and establishing the grantor trust. Shall be fined under this title, imprisoned not more than 5 years, or if the offense involves international or domestic terrorism, as defined in Section 2331, imprisoned not more than 8 years, or both. With respect to any matter within the jurisdiction of the legislative branch, subsection A shall apply only to administrative matters. So this section A here applies only to administrative matters, including a claim for payment, which is the fines, fees, and penalties that they're claiming, a matter related to procurement of property or services. They're telling you you have to appear in court. That's procurement of your services, personnel or employment practices, or support devices, or a document required by law, rule, or regulation to be submitted to Congress or any office or officer within the legislative branch. So these people are administrating the legislated laws, which is the letter of the law, and you have to bring the spirit of the law, which is the heralding of the memorial birthright. That's the thing that's missing. Any investigation or review conducted pursuant to the authority of any committee, subcommittee, commission, or office of the Congress, consistent with the applicable rules of the House or Senate. So the investigation or review of the record that is meant to be entered into the National Archives upon a copyright royalty judgeship by the judges of Congress to enter that material into the National Archives as a matter of historical value. That's all this stuff here. Those fines, fees, and penalties procured is property procured from you that goes into that National Archives as it relates to the national debt. They're claiming you are a debtor. The next one is 18 USC 1015.
Well, according to how we behave, before we become awakened to the truth of things, actually, that would be correct. We behave like debtors, just fighting, arguing, making excuses, and all the activities associated with sin. So I can see, the genius of how this was constructed.
Absolutely. When we look
Right.
at the Redeemer is the only one that can really bring somebody out of debt. They buy back what they sold off. That's how you become a non-debtor. You obtain the things that you sold off that show that you are prosperous, that you are abundant, that you are capable. This is a new start. And it says under 18 U.S. Code 1015, naturalization, citizenship, or alien registry. Registry being a pledge of fealty to the nation. I pledge my knowledge unto the nation, and that's it. Whoever knowingly makes any false statement under oath in any case, proceeding, or matter relating to, or under, or by virtue of any law of the United States, relating to naturalization, citizenship, or registry of aliens, or whoever knowingly, with intent to avoid any duty or liability imposed or required by law, denies that he has been naturalized or admitted to be a citizen after having been so naturalized or admitted, or whoever uses or attempts to use any certificate of arrival, declaration of intention, certificate of naturalization, certificate of citizenship, or other documentary evidence of naturalization or citizenship, or any duplicate or copy thereof, knowing the same to have been procured by fraud or false evidence, or without required appearance or hearing of the applicant in court, or otherwise unlawfully obtained, or who knowingly makes any false certificate, acknowledgement, or statement concerning the appearance before him, or the taking of an oath or affirmation, or the signature, attestation, or execution by any person with respect to any application, declaration, petition, affidavit, deposition. That's a disposition. They depositioned you at birth. Certificate of naturalization, certificate of citizenship, or other paper or writing required or authorized by the laws relating to immigration, naturalization, citizenship, or registry of aliens, or whoever knowingly makes any false statement or claim that he is, or at any time has been, a citizen or national of the United States, with the intent to obtain on behalf of himself or any other person any federal or state benefit of service, or to engage unlawfully in employment in the United States, or who knowingly makes any false statement or claim that he is a citizen of the United States in order to register to vote or to vote in any federal, state, or local election, including an initiative, recall, or referendum, shall be fined under this title or imprisoned not more than 5 years or both. Section F does not apply to an alien if each natural parent of the alien, or in the case of an adopted alien, each adoptive parent of the alien is or was a citizen, whether by birth or naturalization. The alien permanently resided in the United States prior to attaining the age of 16, and the alien reasonably believed at the time of making the false statement or claim that he or she was a citizen of the United States. So this does not apply to you once you realize the impossibility of being a United States citizen. You cannot.
I would also add that, to what you were saying, like I was just making a study of the Federalist Papers, and that document is just, it actually really just lays a lot of this stuff out. If you can get reading comprehension of what's written there in the Federalist Papers regarding citizen and citizenship.
Yeah, and that's one of the primary documents I urge everybody to read. Declaration of Independence along with that, and the original Constitution of the United States. Those are the primary documents that form the trust. And then when we think about citizenship, we were talking about equity earlier, and I mentioned reading up on Rourke and Gibson and them, Pomeroy and all that. And I think another guy that people should relate to in regards to both the equity and the citizenship when it comes to the law is the common law author, Lysander Spooner. Lysander Spooner's writings detail, and it's kind of hard to read because it's Old English, but when you read it, if you can comprehend the basis, it is truly your duty. If you truly are a real citizen of the people, then it's your duty to do this stuff. It's your duty to carry on the law of trust and explain how it works. That's the false, or the fatality, the fault of our previous generations, is they've centered their education directive towards basic mathematics, reading, writing, and arithmetic rather than the actual law. And the forefathers of this nation, before there was a government institution of any kind of public education, from 1494 or 1492 all the way up until 1840, forefathers and the people of this country were teaching their own children, and they taught them basics. And of course, during that 500 years, it switched to the little one-room schoolhouses where they started teaching the basics of reading, writing, and arithmetic. But in the very beginnings, they taught their own children everything, including the law, including trust, including contracts. This is what we missed out on. This is what is not passed on down through the generations. Lysander Spooner is one of the last people to try to do so. And people don't read his writings. We really need to get back to reading some of these older writings.
I do have one of his books in my library, Spooner, and one of the things I recognize is he did use the King's English, and you don't find the word "you" anywhere in
no,
there.
It's ye. It's ye.
right, which
Me and
is
how.
very interesting. That entered where you entered the vernacular as is where the this current system of usury that we're under has has brought that word and seemingly under
Yeah.
the Shakespearean epics as they
Right. And
were
that's that. And
produced.
that's that plurality, that duality. You means plural. It's a plural use, meaning you. And so when I point my finger and say you, I'm not talking about just the individual in front of me. I'm talking about every individual in that forum. So it's a duality thing, and it causes confusion, and that is the debt. That's where the
Right,
debt
and
comes in. Confusion of the
U is
word.
also a EUE. So if somebody's speaking to you, they may not mean what you think they mean. They may mean EUE, and they're calling you a
Right.
sheep. So you might serve that you back to them in a very polite way,
Right.
as
And
much as
that
possible.
goes right back to sole beneficiary, as we were talking about earlier. It's spelled
Right.
one way, but if you're of sound mind, you sound it out, and then express it and clarify it for your use so that they know what
Like
you're using it in
the
reference to.
agent of the agency is the you. But they
Yes.
presume that the man is also a you, um, because the majority are. Therefore, if we can't
Well, yeah,
articulate
everybody's
and
acting
express
that.
the trust that we are not that you that they're looking for, the sheep that they're looking to herd, right?
Yeah, and that's the actions that we go through on a daily basis that make it look like we're a trustee, performing those functions as if though we're carrying an office. And that's what we really need to. That's the total confusion, is that when we're out in public, that we're actually performing in the functions of public office when that's not so. We have our private capacity everywhere I go. And this is one of the things that they use in traffic stops, because you cannot provide the privity, in other words, privacy. They can see into your car. And just by being able to see into your car and see you on with your hands on that wheel, that is an implied operation of a motor vehicle. They're the
Yeah,
ones that have
especially if you have a state plate on the back with a number connected to a contract. That's prima facie evidence for our law enforcement, traffic enforcement to check you out.
right. And that's the window tinting thing. See, the window tinting thing is a violation of natural law, particularly when it comes to privacy. Because if they're saying that you cannot provide for your own privacy, then they're saying that you have to perform publicly, when in fact that's false. Because anywhere you go, if you can provide privity by tinting your windows so that they can't see that you're riding topless, then they don't get embarrassed because some dude's driving down the highway riding topless. It doesn't matter. It doesn't matter if it's a female now, because nobody can see in to see that she's riding topless. Therefore, she maintained the privity, and she can, in fact, travel around topless. The problem is that they say, well, you can't see out the windows. No, we can see just fine. You can even tint the front window. I am going to be one of the ones that will test this, because their very basic thing of public administration is the fact that First Amendment auditors go in there and they can video anything in their public view. Anything in
Right,
public view is public issue. Okay. So they
right.
say that this is this law of privacy, that there is an onus probandi on those that want privacy, that they have to provide the privacy. Well, if I'm trying to provide privacy in my private temple as I'm sojourning with him from point A to point B to redeem some land or property, then who the fuck are you to say I can't provide that privacy? That's in violation of your own law that says the onus of onus probandi of providing privacy is on me. Then when I try to provide that privacy, you're saying I'm violating another law. That's inconsistency within the law, saying that in order to follow this law, I have to violate this law. Can't do that.
Well, I wanted to add, because some of these officers are of low intelligence, simply because we don't have We don't have too many that are very intelligent out here that want to do that work. You can always accept their presentment under duress and then send it back to the Secretary of the State, who then would send it to the Attorney General, who then send it back to the officer to pay on the security, because if you're under constraint, then you can't co-sign on his instrument, and and then it just bounces back to him. And it's, sometimes you just get yourself out of a pinch, because these people can be really stupid and very insistent, and even treasonous to get you to be that co-signer on those traffic tickets. And
and
they
this
don't
is
want to
why,
hear anything about law.
and this is why I make a distinct clarification of that legal name anytime they want to ask me for identification anymore. Sorry, I don't have identification. Well, what's your name? Sorry, I don't have one of those either. Mom and Dad have called me Keith all my life. Now I hail from the family Little. Those are titles. Those aren't names. Okay, get it right.
Well, with the legal names, we're supposed to be the ultimate users only, right?
Correct.
Not taking claim to being a noun.
Correct.
Right. And I mean, ultimate users means the end users. We're not trying to use that to sell it to somebody else, which
Correct.
they presume as users that we can sell our interest to someone else. But as the ultimate user, that's your owner beneficiary position.
Yep.
Right. That's very specific. Which I gave that to a cop the other day, that when I was in town, and the natives were having a powwow, and I was talking to him, and then he wanted to know what my name was, and I told him my name. I said, I'm the ultimate user of that name, so you can't really sell it to anyone else. He said, I'm not interested in doing that. Don't worry about
it. All right. The next one we've got here is 18 U.S. Code 1028. Now, this is fraud and related activity in connection with identification documents, authentication features, and information. Authentication goes to the authority and authorization of the author that is signing it. If you are signing, then you are the one that is authenticating those documents. Okay? But again, like the last one said, you're not culpable if you didn't realize you are not, in fact, a United States citizen. And before I get on with it, I want to explain one more time. I will not get sick of this, but if the states ceded their jurisdiction to the United States, and the United States in the commercial code is known to be the debtor, and the debtor is located in Washington, D.C., and Washington, D.C. is the one that maintains the 10-mile square physical geographical boundary area, and does not have statehood. It is a mayoral form of government and does not have statehood. Then where is the United States? It is merely the record that they keep. You will not find any location that says United States except in a territorial map that includes the 50 states of the Union. That is not, in fact, what the United States is. It is just a representation of a territorial overlay for the maritime transactions known as commercial contracts. Therefore, it is impossible, if the United States is located in Washington, D.C., and is just a set of records, and that set of records has no birth registry, therefore there is no one recorded as being born in the United States record, other than those that are stated as born as residents in the states, then you cannot possibly be a United States citizen. It is, in fact, an impossibility. Whoever.
Of course, unless we contract for that specifically with knowledge.
Correct. And
right.
that's through the taking of an oath, the organizing as a corporate charter through the Federal Reserve, taking upon certain documentation that you hold in your office and keep records of as well. Now you have a duplicating system where the United States gets records and you have your own records where you, when they take you to court, you can concur or defer to something else. 18 U.S.C. 1028, as it relates to the fraud and related activity. Again, it's actions. You're acting in the functions of, or in performing the functions of public office as that's deemed the activity of signing those documents. Whoever, in a circumstance described in subsection C of this section, knowingly and without lawful authority produces an identification document, authentication feature, or a false identification document, knowingly transfers an identification document. This is what the brother Chris was just talking about. Authentication feature or false identification document, knowing that such document or feature was stolen or produced without lawful authority. Knowingly possesses with intent to use unlawfully or transfer unlawfully 5 or more identification documents, authentication features, or false identification documents. Knowingly possesses an identification document, authentication feature, or false identification document with the intent such document or feature be used to defraud the United States. Again,
Is that every officer that has a an officer ID card with his image on the right-hand side of the document instead of the left-hand side of the document, claiming to be a creditor?
I don't know how that works. All I know is it's an identification document as it relates to a debt being posed against the United States, and that is the fraud against the United States. There is
Right.
no
Well,
debt
I was
against the
just saying,
United
like
States.
in the sometimes when I speak with officers, I get them to show me their identification credential to work as an officer, and I took note that the image is not in a box on the document, and it's on the lower right-hand corner, and not in a box on the on the left-hand upper left-hand corner, as it is on the driver's license.
Yeah,
Right.
I don't know how that works legally. All I know is it does have a title on it.
Well, the left-hand side is the debtor, and the right-hand side would be the creditor.
When it goes,
Right.
when it comes to
And
when it comes to the paper documents, yes, but that's not necessarily a paper document. So I would have to research farther to confirm that, but it would seem reasonable and logical because it would follow the same as the document.
right.
But
I just want to take note of that, because what you're reading is you're saying that these people using documents to make claims, and it, you know, it would seem that some of these agents are making a false claim by presenting that document as identification, right?
right, and that goes to that citation where they make the complaint and stuff, where the conversion happens from the last name to a firm name. Once they hand
Right.
that document off to somebody else, the DA, now the DA draws up an instrument and attaches their own case file number to it, or case number to it, and then goes to the clerk, and the clerk uses that information and creates their case number for it. So there's a prosecutor case number and a clerk of court's case number. And those are documents that are duplicating themselves to support the complaint, which is
And then the clerk is
if it's
appointing a trustee to manage that security.
correct,
Right.
because if it works the way you say, which is presumably accurate because it's the same way I see the documentation, that the officer is acting as the creditor, accepting a debit from the guy on the side of the road, and then as a
Right. And that's
creditor,
why he has to co-sign to be the principal. Right.
right, and that's why they go forth with that, and it comes in as a creditor claim on the docket.
No, I say it's a co-sign because there's a line with an X on it, and the X is indicating that X marks the spot, and it's already been signed.
Yes.
Right. So now they need you to co-sign. Right.
The next one, it says knowingly produces, transfers, or possesses a document making implement or authentication feature with the intent such document making implement or authentication feature will be used in the production of a false identification document, naming a man as a defendant. That's a false identification document. A man cannot, again, just like a United States citizen, it is impossible to be a defendant as the term is written out. You have a prefix and a suffix that change the conditions of the original root word, which is fend, and that places it in concise English as an abstract noun, meaning total fiction. So they took, again, like the tangible act of being born and converted it to an intangible act. It's the same thing. Or another document making implement or authentication feature which will be used. Knowingly possesses an identification document or other authentication feature. And this all has to do with transfers in that, like I said. And it says the punishment for an offense under subsection A of this section is, except as provided in paragraphs 3 and 4, a fine under this title or imprisonment not more than 15 years or both. So now we've gone to from 5 years to 8 years to 15 years. A production of or transfer of an identification document, authentication feature, or false identification document that is or appears to be an identification document or authentication feature issued by or under authority of the United States. That identification is issued under the authority of the United States, and any claim made by it is claiming a debt against the United States for the issuance of that very document. A birth certificate or driver's license or personal identification card. Except as provided in paragraphs 3 and 4, a fine under this title or imprisonment of not more than 5 years or both if the offense is any other production, transfer, or use of a means of identification. An identification document, authentication feature, or a false identification document. Means of identification. The means of identification of mom when she went into the hospital was the given name and the family name. And Social Security openly admits that they translate it to a legal name. Any other production or use of a means of identification. The Social Security Administration uses the means of identification of mom, giving a first name known as the given name, and clarifying the last name or the family name is then translated by the Social Security Administration, knowing that it's a given name and a family name. It is translated to a legal name. That's a 15-year sentence just for producing that document. A fine under this title or imprisonment for not more than 20 years or both if the offense is committed to facilitate a drug trafficking crime in connection with a crime of violence after a prior conviction set or under this section becomes final. In connection with a crime of violence, every time that they demand that you use that identification, that is a threat of violence that if you don't, they will take you to jail. That's the crime of violence, is the demand of the identification. This is not a communist Nazi country. Okay?
Right, and that's where one can present that alternately identifying number for the record.
Right,
rather
and
than
that would be a separate trust number established as a private trust in confidence.
Right.
These private,
like I did that because when I travel, I went and got I got a permit from the state, which is a permission to practice the thing called driving, right? But it still keeps me in the beneficiary position to have a permit if I decide that I'm going to participate in some transportation, trade, traffic, right?
Absolutely.
I'm only practicing. So whenever I have to deal with a pullover situation, I generally will present the permit, the number only of the permit, which they can put through their system and realize that there's something there as a permit, right?
Correct.
Right, and then I've never had an issue with that for 20 years, and I just keep paying the fee for the permit to update the permit because I continue to practice. So I'm not become an expert in these things enough to be a trustee, right?
Correct. See, you're not a professional. You're not an
right. So,
expert.
I have the capacity to practice, and then I have a licensed driver with me because I have all my friends that have driver's licenses, and I can dial them up on my phone at any time if I have a question about my driving practice. Right.
Yep. Do you ever travel alone?
I try not to, but I never travel without my device and at least 5 or 6 people on speed dial that I could basically
Absolutely.
let them know, right? And they have right, and then I have two cameras, one on the outside and one on the inside of my vehicle, so I'm getting all the footage of everything outside and inside the vehicle. And then I have a transcriber program on one of my devices. So, in the event of a traffic stop, like the Otter transcriber will transcribe everything that's said, right? So that's my court reporter.
Absolutely, and that's the kind of stuff that we need to start doing. I've spoken on this before when it comes to the community watch programs. We've got people that sit on their porch that are on disabilities and stuff, and they like these devices. And I think it's pertinent that we start viewing or recording the neighborhood when we're doing those kind of things. If we've got the ability to do so, like the Ring doorbells and the security cameras and stuff, I think we should implement those more for our own use. It would be a great help. And in the meantime,
generally, I only when I travel privately. What's that?
In the meantime, we've got the Fallon that has joined us. Greetings, Fallon. How you doing today, brother?
Greetings.
Oh, I'm doing good. I was on mute making a salad. Hey, I had a question though. My question is like when you talk about the name, when you said like if a policeman or some agent tries to interact with you and they go, "Let me see some ID," and you're like, "I don't have an ID. Let me hear your name. I don't have a name." My parents called me Keith, and I'm from the family a little. What if you're adopted? How would you think in your head a person would go ahead?
Well, yeah, I am adopted. I am in fact adopted, and what they're looking for is that the legal name. So I'm going to give them the elements as the legal name is recorded, but I'm going to give them in a different format. So the format is not the first and last name. I'm not going to give them a first and last name. I'm going to declare and clarify that I do not have a name, but my mom and dad have called me Keith all my life. Now, the premise of this is that I do not have a name. How can I prove that I do not have a name? You show me anything on my person that has that name. You can't
So do
find it.
you go
There's no
by
evidence.
when you say the family of? So you're going by the adopted one. What about the name you had
Yes.
previous to an adoption? What if you
You can
chose that name?
You can
What if you?
clarify that as well. You can clarify that as well. But if you haven't corrected the record yet, it really doesn't make any difference until you
Okay.
correct that record. Once you correct that record and tie the adopted name back to the legacy birthright name, now you can clarify I was adopted and the legal name was changed to Keith Little. But again, that is the legal name. That is not my given name, which I've been called all my life, which I do not have. It's a calling. Again, You will not
Right.
find that name
That
wrong.
shows that you're not an idiot, Keith.
Right.
According to the definition of idiot, you understand your nativity, you comprehend what your nativity is. Therefore, you can't be an idiot that IDs.
Correct.
Right.
Correct. So I hope that answers your question there, and we're going to get on to the next one
Okay.
here. A fine under this title or imprisonment for not more than 30 years or both if the offense is committed to facilitate an act of domestic terrorism. Now, when that officer pulls me over side the road and tries to tell me that I have to give him identification or he's going to take me to jail, that is domestic terrorism. And I don't give a fuck whether he has the knowledge or not. He's supposed to have the knowledge. He's supposed to be able to use his professional discernment. And if he doesn't have the professional discernment, then I will forever profess the truth, and he will forever be a domestic terrorist vying against the truth. That's the whole basis of all of this. They go by the material facts on a record, and they want that legal name so they can match it up to a record. There is no duplication of that record if I do not have a name. I'm not going to give those data elements anymore. I don't know what you don't understand. I'm not a corporate entity that has duplicate records. Nowhere. As defined under Section 2331 again, or an act of international terrorism. And because I am not the domestic one, when it comes to the legal name, it covers both domestic terrorism because he's using domestic devices, and he's committing international terrorism at the same time. I reside at the international forum. I'm not of this world. I'm in this world. I come from outside. I didn't come from the nation, and then there's an external something other greater than the nation that I came from. No, that's not the way it works. I came from something greater, and I exist in this world.
You're not of the world of man.
Correct. So we see
Right.
now we have a 20-year and a 30-year sentence in this one. In this section and section 1028A, which we're going to look at next, the term authentication feature means any hologram, watermark, certification, symbol, code, image, sequence of numbers or letters, or other feature that either individually or in combination with another feature is used by the issuing authority on an identification document, document making implement, or means of identification to determine if the document is counterfeit, altered, or otherwise falsified. It is not a counterfeit. It is not altered. It is falsified. Again, the actual tangible event that was supposed to be recorded was recorded as an intangible event. That is a falsification. And it only happens because mom and dad don't make the proper declaration. I think that's all I've got for this one. There's a little more, but you can get into that. Like I said, they have other terms and all these blue line highlighted terms, you can click on them. They're going to give you definitions. Personal identification card means an identification document issued by a state or local government solely for the purpose of identification. So it doesn't mention the United States when it comes to personal identification. So there is no personal identification of United States citizen. Again, an impossibility. No one has an identification saying they are a United States citizen except for the passport, which is dependent upon the resident personal identification card. Okay? It's an
Can you speak to what
impossibility,
you mean by the declaration? You were speaking to declaration and what mom and dad aren't doing with respect to
A
declaration.
memorial. We talked about that,
There you go.
the memorial birth certificate. Mom and dad failed to
Uh-huh.
memorialize the coming of a legacy heir. And that memorial is a handwritten statement declaring that we have, behold, a child of God has arrived, and we will train him up in the ways of God so that he can surpass the temptation of the demons in this world and shew unto the heirs of righteousness the word of truth, as scribed in his heart by the index finger of the right hand of God. Whatever, something like that. You're supposed to bring forth a herald. You're supposed to herald the coming of your son, your heir, and that's what's missing. So the next one,
and then get not to grant and convey that biological property vessel that he or she came in on. Right, that becomes a situation of a curse that has to be undone when they
correct,
take that
and that's why
biological property.
and that's why everybody signs their signature in cursive. Before, it used to be your mark. You could put your mark on a document. That's not signature. That's not cursive. Why do you think Prince changed his name to a symbol? Because nobody could get away with copying the symbol. They didn't have the right to do so. And anybody seeing somebody writing that symbol down as their signature would most certainly get in trouble.
That's why they had to kill. That's why they had to kill his public person.
Yep.
Right. Because he changed it to a illegible, so he went onto the private side, and as far as the public's concerned, he's dead.
Okay, 18
Right.
USC Code 1028A, aggravated identity theft. Whoever, during and in relation to any felony violation enumerated in subsection C, knowingly transfers, possesses, or uses without lawful authority a means of identification of another person shall, in addition to the punishment provided for such felony, be sentenced to a term of imprisonment of 2 years. So the nurses at the hospital telling you that you have to sign this document, making a legal determination, are doing so without lawful authority. Calling DHS and saying you won't sign documentation and having DHS come in and take your child without lawful authority is aggravated identity theft. And every last one of them should be put to this for 2 years as a starter. You have no lawful authority. I have been redeemed. I fear not. He has called me by thy name. I am his. Who the fuck are you to tell me I have to write my name down in cursive letters on your documentation? None. Terrorism offense. Whoever, during and in relation to any felony violation enumerated in section 2332B G5B, knowingly transferred, possesses, or uses without lawful authority means of identification of another person or false identification document shall, in addition to the punishment provided for such felony, be sentenced to a term of 5 years imprisonment. This is the documentation. A false identification document. There is no need, no pertinent need to create a legal fiction for the man that was discharged of his mother's water on the day he was born. The only time that it is necessitated is at age of majority, when mom and dad release him from their house and say, now you can go out upon the world and act appropriately. It is their duty to help their children become aware of the manual operation of this personal system. If they don't, then they are an idiot, as our man said earlier. They don't know. And if they don't know and they're incompetent, the courts cannot hold anything liable against them again. So the creation of the false identification document at birth is in fact a felony It is aggravated identification theft. It is a domestic terrorist act upon an international being. Notwithstanding any other provision of law, a court shall not place on probation any person convicted of violation of this section. In other words, there has to be a prison term and they have to serve the sentence full. Except as provided in paragraph 4, no term of imprisonment imposed on a person under this section shall run concurrently with any other term of imprisonment. In other words, they have to run consecutive, same time at it. So the 2-year sentence and 5-year sentence run at the same time. The 2-year sentence will run out before the 5-year sentence. If you have a 30-year sentence that's running the same concurrent time as the 5-year sentence and the 2-year sentence, those two sentences will discharge before the 30-year sentence. Okay? That's all it's saying there. For purposes of this section, the term felony violation enumerated in subsection C means any offense that is a felony in violation of section 641 relating to the theft of public money, property, or rewards. Public money, property, or rewards. No one has stolen public money, property, or rewards unless they use that very identification themselves to obtain money, property, or rewards. So again, if the Social Security card is a card, device, or credit device used to obtain money, property, services, or labor on credit, there is no theft. When you get the identification by using the Social Security card and the birth certificate to get the identification, it poses that you're an agent. Get to use that public money, property, or rewards freely. Therefore, there is no theft. The only ones that can be charged with theft are the ones administrating the trust. The ones that are saying you have to sign your name. The ones that are saying you have to appear in those courts. The ones that are saying that you have to do this, this, and this, when that's false. You ain't got to do a goddamn thing unless your God told you to do it. Section 911 relating to false personation of citizenship. So let's take a look at section 911, 18 U.S. Code 911. Citizen of the United States, whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years or both. Whoever falsely or willfully represents himself, whoever falsely and willfully represents himself to be a citizen of the United States. United States citizenship is false to begin with. It is an impossibility. There is no birth registry in the United States. The next one. Theft or alteration of record. 18 U.S.C. 1506. 1506. Theft or alteration of record or process. False bail. Theft or alteration of process. Theft or alteration of record or process. The alteration of process. The recording of an event, a tangible event, altered to the recording of an intangible event. Okay? It all goes back to the enumeration at birth. It's all false. Whoever feloniously steals, takes away, alters, falsifies, or otherwise avoids any record. And this is why I say You have to put your memorial out there. You have to let them know, no, you cannot avoid this record. Okay? You have to institute your record as primary, as priority, as superior, as superseding their legal laws and their legal trusts. Avoids any record, writ, process, or other proceeding in any court of the United States whereby any judgment is reversed, made void, or does not take effect, or whoever acknowledges or procures to be acknowledged in any such court, any recognizance. Do you cognize it and then recognize it? Acknowledged in any such court, any recognizance. So when you were born as a man or discharged of your mother's waters and born a living soul, and that event was not recorded, it was not cognized. What was cognized was the legal name, the establishment of a legal entity. Then that is brought forth each and every time in all situations throughout our life, even in school. When we go to school, the teacher starts telling us how to write our first and last name. Then it morphs into signing our last name in cursive. Okay? That's a recognizance. You're supposed to cognize first before you can recognize. Therefore, everybody in this system that didn't know about the legal name and its attributes was not cognizant of it to begin with, and therefore couldn't recognize it later. They assumed it was themselves. Bail or judgment in the name of any other person not privy or consenting to the same. I do not consent. Like our brother Chris said, that's the ultimate owner. We are the ultimate owner, and we do not consent. They can't say, yes, you do. You have to. We're going to throw you in jail if you don't. That is the violation of law. That is the terrorism. Shall be fined under this title or imprisoned not more than 5 years or both.
I have a question.
Sure, go ahead.
I was just I was making some kind of a mental note, and I'm feeling that, and somewhere in this is like when they claim a us versus them, and like we're always treated like criminals, is because we're actually, according to what you're reading, we're all guilty of that. That's why we're treated like criminals. And
Absolutely.
once we start acting as that trustee, then they demand our signature again as a trustee, or you're going to be fined by these laws because you're not performing the duty that you're required to do because you're actually acting in that capacity.
Yeah,
Yep.
you're
So
acting like a raccoon.
Yep,
So
absolutely.
they treat you like one.
Yep. And the next one is going to hopefully help clear that up, I hope. 18 US Code 1512, tampering with a witness, victim, or informant. Who was an informant first and foremost? And who was told that if they didn't sign that document that they wouldn't be able to take the child home from the hospital? What kind of threats were made? What kind of inducement? What kind of tampering was done with mom that induced her in labor of doing his good works to sign birth registration documents? Whoever kills or attempts to kill another person. Now, killing with necessity is lawful. So I'm killing off the person as known. Keith Little.
Well, it actually starts with the prenatal paperwork. I
Right.
believe the record starts there, where and that's where she's not given adequate notice as to
right. That's a general
what
ledger.
capacity she needs to operate in.
Yeah, that's a general journal. And then when she gets to the hospital and bears her young, it's converted to a general ledger and allonged.
That's right.
Yep. Whoever kills or attempts to kill another person with intent to prevent the attendance or testimony of any person in an official proceeding, prevent the production of a record, document, or other object in an official proceeding, or prevent the communication by any person to a law enforcement officer or judge of the United States of information relating to the commission or possible commission of a federal offense or a violation of conditions of probation, parole, or release pending judicial proceedings. Release pending judicial proceedings. So when you sign that release document at the jail, the release paperwork, it's a release pending judicial proceedings, saying that there will be future judicial proceedings. In other words, they're going to persecute you if you violate one of those state statutes that have been judicially determined through fines, fees, and penalties. And they will assess those judicial fines, fees, and penalties at the next proceeding when they pull you in as a trustee, like our brother, the fallen, had just mentioned. We're presumed to be a trustee in violating those trust codes, those contracts under trust law.
And then they trade those things on the secondary market, of course.
Whoever uses physical force or the threat of physical force against any person or attempts to do so with intent to influence, delay, or prevent the testimony of any person in an official proceeding, cause or induce any person to withhold testimony or withhold a record, document, or other object from an official proceeding, alter, destroy, mutilate, or conceal an object with intent to impair the integrity or availability of the object for use in a proceeding. Integrity. It has to be integral. It has to be enumerated. That's what integers are. That's what it means. It has to have an arrangement in value according to the enumeration.
So that enumeration puts us under that Department of Agriculture as well, right?
Yes. Yes, it's a birth certificate.
we become farm products. Or
Yes.
farm animals.
Owners register the birth of their animals, their stock. Owners register the birth of their stock so that they can be kept track of. That's called earmarking.
There you go.
The certificate will match the number marked on his ear. Again, I do not have a name. You find a name on me and I'll suck your cock. It does not exist. I am not earmarked. Evade legal process. Evasion and avoidance are two different things. Legal process, summoning that person to appear as a witness or to produce a record, document, or other object in an official proceeding. As a witness, again, another material fact that is altered when they call you a defendant. You are not a defendant. You cannot be the abstract noun. You are not a person, place, or thing. You are a what? A verb. Every breath is an act of God. And as an act of God, everything I state is as true as I believe it can possibly be. Or be absent from an official proceeding to which that person has been summoned by legal process. Again, summons in a legal process requires a waiver of personal jurisdiction. If somebody is saying that they are summoning you to a court for legal process, then they didn't give you a waiver of personal jurisdiction, then it is a false summons, like the one on the side of the road when he issues a traffic citation. There is no summons on there. He is trying to summons you, and it acts as a summons, but there is no waiver of personal jurisdiction that you can attach to it.
That's what a dark sorcerer does. He summons the spirit.
And what's he do when he summons the spirits? He has a concoction of things that are mixed and jumbled together.
Yeah.
Taking a part of this and a
And
part of
so
that, part of that.
that's where he's managing the underworld.
Right. And then he's taking a part of you, which is your person, the name. And then he's going to take a part of another person, which is their name. He's going to take a part of another person, which is the legal definitions. Going to take part of another person, which is the legal description, the fines, fees, and penalties. It's just a conglomeration of persons from various different persons.
Right, which is
He is a respecter of no person.
giving. That's what's giving the jurisdiction, making it the business of the underworld, because we're falsely identifying with the idol.
Yep. To produce a record. To produce a record. That's all they're doing. They're trying to produce another record. If not, they would already have the record. They would pull it out of their pocket and say, according to this record, blah, blah, blah. They don't do that. So what they do is they're evading legal process by summoning you to appear as a witness in a court as a defendant to produce a record, document, or other object in that official proceeding, as if though you are a trustee. It can do so because you have those records. If you don't have those records, you cannot be forced to produce them.
They have them for you because they're treating everybody as an acting trustee. That's the only way the laws and everything can comply or do apply to everybody, like, say, driving or traveling, because everybody has become a trustee. It's like you said, instead of teaching us how not to be a criminal all through prenatal, through school, they've taught us criminality. We are the criminal. And it seems like if we don't change the record, like you're suggesting, or that it doesn't matter. If we make another claim on who we are, we're liable to get stuck with the penalties that you're reading because we're making a falsehood and trying to declarate that we're a different identity. So if they don't have to pull the record forward, any record they get's going to be on that computer to go to that record of them pulling something out of their pocket at those stops. It's like, as a trustee, you broke that trustee limit that's on that sign over there. That's not for anybody, let's say, who hasn't corrected the record. So even if I state it and you claim that, or your statements are that I can correct the record verbally, is like, so if you're on that side of the road of that postal thing and you're trying to correct the record verbally, the record he's going to pull out is the record that's on record that apparently hasn't been corrected. So there's the kind of like the rock in the hard place. If I'm thinking, if I just got put in that position, I'm kind of stuck, because if he threatens me, to say that he's committing violence on me in some way, he's holding me accountable for being a trustee and me ganking up my trustee responsibility. And in doing that, there's a penalty of that your reading can be placed on me because I've ganked up my trustee duties when I'm not a trustee, but I've been taught to be one.
And that's because everybody's been going under this administration of the public trust. And once we establish our private trust, the Keith Orland Little FBU trust, with a judicial account in the judicial office, which is with the post office, now we have a trust account that we can refer to that doesn't associate with the public trust except through the administrative record. So now they can go through the administrative record, like I've been explaining about the homemade prepaid postage thing. It goes through the mails. Now it's sitting in the judicial office as an express trust, and it's just waiting for the funds. They can't administrate anything because they know there's no funds. And it's
So
not
is that, so what you just said, I mean, in a concise thing, because there's a lot of information, but I think you just said something really important. My brain wants to grab on. If you'll rewind and say, when you're talking about changing the record, because this is like a very important, like a first step deal, you said you have to go something through the postal union. Can you rerun your brain back and make that first statement?
So So when the enumeration at birth happens, it creates an administrative docket for the administration of a legal entity. That legal entity is a contract officer in the public trust because it's in the public document. When you go and address that administrative law judge and express that trust, you have to merge the old trust. It's a resurrection. And you're going to resurrect the convicted felon, the legal entity that's been behaving so badly all his life. You're going to resurrect him. You're going to kill him and then resurrect him in a merger with a new name, the Keith Orland Little FBU Trust. It still holds Keith Orland Little, so they can still go through their administrative docket and see that, yes, that's Keith Little, and it ends up being the Keith Orland Little FBU Trust. Okay, we recognize he killed off the administrative legal entity known as Keith Little and now operates as the Keith Orland Little FBU and has a trust set up in that name.
Through the
Right.
postal
And
union,
that
though.
way
That's the key.
you can't be presumed to be the defendant. Right.
Correct.
When we
And
we break that down,
that trust account is set up with the post office through the online enterprise payment system. And when you set up that account, you name it a trust. That way it's an express trust. And it, like it says, it's a trust. It just doesn't have any funds yet. We're waiting for the correction of the public trust so that the remainder man can step over and reside in the new private trust.
right. And also, when we look at this word defendant, we can break it to two parts, which is D and fend, and then ant, which is actually three parts, which I look at as D, meaning, which is a negative on the word fend, right? To fend for oneself, like to fend, and then ANT is a contract. So we have a no fendant contract, which, and it also reminds me of the word deaf, right? Like the one who's contracting is deaf. They can't comprehend, they can't hear, they can't understand, so they have no defense.
Yep.
Right? They can't, and that's why they need an attorney to act on their behalf, right? Because they're deaf and they have no capacity to fend for themselves.
Okay. Continuing on, the punishment for an offense under this subsection is, in the case of killing, the punishment provided in sections 11:11 and 11:12. Let's look at those. Of course, that's murder. Okay, and murder, whoever is guilty of murder in the first degree shall be punished by death or by imprisonment for life. So there's a death or life sentence. And the next one, I believe, is going to be like manslaughter. Yep. Manslaughter. It is of two kinds: voluntary upon a sudden quarrel or heat of passion when we get into our emotions, or involuntary in the commission of an unlawful act not amounting to a felony, or in commission of an unlawful manner, or without due caution and circumspection of a lawful act which might produce death. In other words, it's in the commission of a felony that you kill somebody else. So you're robbing somebody. So there's a felony of robbery, and in that robbery you kill them. That's involuntary manslaughter. Voluntary manslaughter is when you're in a heated quarrel with your wife and you accidentally kill her. That's voluntary manslaughter. Both of them, 8 years. 15 years, 8 years. So let's take a look. In the case of an attempt to murder or the use or attempted use of physical force against any person, the use or attempted use of physical force against any person in an attempt to murder or the use or attempted use of physical force against any person. Imprisonment for not more than 30 years. In the case of a threat of use of physical force against any person, imprisonment for not more than 20 years. The fellow on alongside the road, giving out the traffic citation, using his emergency lights to do so, is declaring emergency and is a 15-year felony sentence for doing so when there is no emergency. That is in the commission of a felony, and if he accidentally kills you, that's involuntary of a felony.
And what is the law at the time of an emergency, Keith?
It's got to
Right?
be
There is no law that they are obligated to follow at the time of an emergency.
right. But at the time of an emergency, it's an emergency, so there is no law to follow. So they put on the lights to let people know they're not going to be following the traffic laws. They're going to be speeding. They're going to be going through those red lights. They're going to be doing this. They're going to violate that written law as it's written, because the intent, the spiritual intent of the law as it relates to public concern and public interest is the emergency care of people that need it immediately, right now, the now time.
Right.
Time supersedes all law.
So that's always a nice question in the event of a traffic stop is, what is your emergency today? Because they can ask the civilians for help. So you don't want to presume, you want to presume that you want to be a good Samaritan and possibly help him if he wants help. And maybe he's pulling you over because he needs help. But, that's a good question to ask them. What's their emergency? Because we wouldn't presume to know that they don't need help.
Yep.
That's the way I look at it anyway.
The next part, whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years. So the people on the bench in the last two court appearances, wherein I went in to correct that record, let them know that record is in error, they continued on and corruptly documented a continuance, posing that they had on record personal jurisdiction, which they do not, and therefore otherwise influenced or tried to influence me, telling me I have to appear in another court appearance as a continuance. No, don't think so. Our agreement was you were going to dismiss the bond and send me a new summons. And then upon receipt by the registered agent of that summons, according to the international address format that I gave you in care of Joyce, we together would be able to discern whether we could receive it or not. That is the falseness. You cannot continue something that wasn't received to begin with. That was the clarification. I never received anything. Okay, well, we'll dismiss the bond and send you a new summons. Now that you have a proper addressing format that it will reach me, then it will reach me. Then I can make my abatement on the envelope, or I can open it, read it, and fill out the questionnaire, showing that by fact of the questionnaire that I am not subject to jurisdiction of jury duty because I am not a United States citizen.
Well, you're also not participating in their commerce realm.
Right. I'm not a resident. I do not have a
Right.
bank account. Have not had one for 7 years. I have no funds. I have no income. I haven't had any income for 7 years.
Mm.
These people are screwed.
I have a question real quick.
They're
Um,
they're
when
facing 20 years. Go ahead, brother.
when this gentleman used the word Samaritan, what do you feel that word Samaritan in your studies in a legal aspect or whatever? Do you think that's a good classification of a Samaritan, or do you think that that's still, in a way, a noun instead of a
It's a
verb?
Samaritan, but the Samaritan is same thing as a benefactor. It describes the person that gives. So in the noun, it provides an action.
Thanks.
So the Samaritan is the same
Yeah,
thing
it's
as a
based on a
benefactor.
presumption that you want to help your brother, right?
Right. Yep.
Yeah.
Okay.
So I
So the
could
next
just,
one.
okay.
Go ahead. Go ahead.
No, I was just looking at that. I was just thinking of that in the aspect of an identification. I mean, if you felt in some way to identify, then you could identify that as more of a verb than as a title or a noun.
Correct.
Like even though you don't have an ID on you because there's no name upon you, because it's a lot like talking about identifying yourself as a person or a this and that. Those are like wrong ways to go and identify yourself.
Yes.
Okay, thanks.
Okay. Under 18 U.S. Code 1589, forced labor. This is the doozy, folks, because like I said, they can't tell you you have to sign that document. That's forced labor. That's forced labor according to their code. And we're going to read it.
You know, they can't force you to co-sign their instruments.
Nope, not at all. It says whoever knowingly provides or obtains the labor or services of a person by any one of or by any combination of the following means: by means of force, threats of force, physical restraint, or threats of physical restraint to that person or another person, by means of serious harm or threats of serious harm to that person or another person, by means of abuse or threatened abuse of law or legal process, by means of the abuse or threatened abuse of law or legal process. And we're going to see how this changes down below in subsection C.
So this
By
is all
means,
about if they're creating securities and essentially you're giving them a loan of your credit and they're
correct,
forcing us to do that and that's unlawful.
correct.
Hmm.
By
I just
means
wanted to
of any,
summarize what I understood.
yep, by means of any scheme, plan, or pattern intended to cause the person to believe that if the person did not perform such labor or services, that person or another person would suffer serious harm or physical restraint, shall be punished as provided under subsection D. Whoever knowingly benefits financially or by receiving anything of value, such as a paycheck, from participation in a venture as an investment, investigation. Okay, that is the venture. It is an adventure which has engaged in the providing or obtaining of labor or services by any of the means described in subsection A, knowing or in reckless disregard of the fact that the venture has engaged in the providing or obtaining of labor or service by any such means, shall be punished as provided in subsection D. So all we have to do is clarify that knowing in their reckless disregard of the enumeration at birth, the people at the hospital did in fact commit a crime under 18 USC 1589 called forced labor while mom was in labor and told her she had to sign this document. Bullshit. That's a lie used to produce documentation. It's a lie if you don't know the truth. In this section, the term abuse or threatened abuse of law or legal process means the use or threatened use of law or legal process. The term abuse means use. Do you understand what this is saying? The term abuse or threatened abuse of law or legal process means use or threatened use of a law or legal process. So you take the AB off, like you would take the AD off in adventure, and you find out it's a venture. And what they're doing is using or threaten using of a law or legal process, whether administrative, civil, or criminal, in any manner or for any purpose for which the law was not designed, in order to exert pressure on another person to cause that person to take some action or refrain from taking some action.
And
And
now
in
that we have heard that, now we're fully liable if we act against it. And
correct.
exactly. I mean, if someone doesn't know these things, then we can't necessarily prove that they have a guilty mind or a guilty intent. But now that now that we bring these things out and they would hear them, they've become culpable under heaven's law.
It
Yeah.
has to be a law. It has to be a law used for what it wasn't designed to be used for, though. It has to.
Correct.
The way you read it
And
right there is
and
they got to
and
threaten you with
the
that.
enumeration at birth is the establishment of a legal entity. Who is supposed to create a legal entity? Can I create a legal entity for you?
No, well, without my permission, you can't. Or
Right.
no, I guess you can't. I guess I would still have to do it. You would have to, like, co-sign it
Exactly.
or something.
So can a legal entity be made and established in the name of the baby that was born? No. It is a legal impossibility. Again, that legal establishment to be used in this governing world has to be organized under the laws of the United States. By placing a presumption on the record 18 years before that event can even happen is fraud.
That's the law being used for the purpose it wasn't intended to be used for.
Yes, it is creating a legal entity for use in commerce when the one that is capable of doing so may not name it such when he becomes capable of doing so. He might name it Waterworks because it's a water ride park. He's not going to create a legal entity and name it Keith Little and then try to convince everybody it's a water park. He would have a much better advertising and outreach if he advertised it as the Waterloo Water Parks. And guess what? Keith Little owns it. See the difference? See, the Keith Little is supposed to be the identification in a trust, not a legal entity that performs contracts. The legal entity is supposed to be the production of that legal person, his imagination. It is the intangible thought that he has that is created tangibly, that creates a business that can then be logged in records to keep track of the commercial activities. Without
That's
all
what
that,
they call the natural. That's what they call the natural person. Your highest legal capacity as a natural person
correct,
with a
correct,
durable power of attorney over the legal title, legal person.
right, and that's the legal title.
Mm-hmm.
See, it's not a legal it's establishing the legal name. Okay, and the legal name is used for legal things.
Like
So when they
things that are in
construe
the
this legal,
in the world are legal, right?
so when they construe the legal name as the same as the given and family names, it provides a route for duality where they can bifurcate things and take over the legal name. And that's exactly what happens when they do it at enumeration at birth. They start using that documentation as if though that's the authority that they have over the child in case mom becomes a druggie or something.
Right. The
They own
Vatican
the
Hey,
had
check
to
this
do
out.
that. They had to create that trust a long time ago because of all the women and the children being abandoned because men go to war and cause themselves to be killed, and
Correct.
they become then wards of the church, and the church has to do the administration, so they had to create this fictional trust system to manage the wards of the
Correct.
counties,
And then
So
the
parishes.
they
church,
used the law for what it wasn't intended to be used for.
right.
They
They
actually
use it.
used the law, that corporation law or whatever, for something it wasn't really designed to be used for, because then they claimed authority over a living being instead of a corporation, of a
Right.
commerce corporation.
And the law that they violated was trust law. They named they established the legal name of a legal entity, and that exposed the beneficiary. That exposed the benefactor. You're not supposed to expose the benefactor in a trust. And that is what is violating is the trust law. The contract
Well,
law is violating the trust law.
also the legal name is the name that's the capitulated form of the name, right? And that's a word mark. It's not a word. It's not an English word. It's a word mark,
Correct.
which falls under that attorney word product doctrine that they follow, where words generate currency for their
Yep.
empirical system. Right.
Yep, and that's what I found the obligor number thing under in the Government Publishing Office Styles Manual is a thing called an all mark. And I'm going to post a comment in the chat, and what you see there is known as an all mark, and that is the beginning of the financial document. Underneath the firm name that they put, they have obligor, and that is how they start out the term obligor. And that obligor with the all mark and then BLIGOR after it is a word mark, just like our brother Chris just said. It's a word
That,
mark that denotes that there's a derivative, and that derivative is from an all mark. What's an all mark? Well, an all mark covers everything on a document. So what I found in my research, I mentioned it yesterday, is we're not supposed to be marking our signature on the bottom on that dotted line with the X or anything. We're supposed to put our name at the top and then date it. That way it shows we come first. That's why I say I don't know about the left and right hand side fully yet. I do know that on documentation, the left hand is the debtor and the right hand is the creditor. But in the documentation, when you put your name on the top with a date, that's not a matter of credence. It's a matter of fact that you come first, and nothing can be consented to unless you know all of the terms. So it's time to sit down at the table, and we'll sit down and discuss each one of these terms as they apply. If they don't apply, they get dismissed. At any time that something gets dismissed and qualifies the document as invalid, then it is invalid at that point.
So
right.
why
And
do you?
that's what
What,
you're just saying keeps us out of falling into that attorney word product doctrine, uh,
Correct.
falling under that, right? Because
but why do you
we're
think that
becoming the underwriter on those securities and not really understanding what's going on with the commercial endorsement
why
that we're providing them.
why do you think that that person changed that into a continuance instead of the releasing the bond? Why do you think that she went and took and made that a continuance so that when you get that letter or whatever, whether you decide to open it or not and discuss those terms that may be on there to figure out whether they have that capability of the jury duty summons, why would she not keep her word in that? Why did she do that?
Be- Because there's 93 cases on that docket prior to that that suggest that the court does in fact have personal jurisdiction. However, that suggestion again is an error according to the principle that the court can only obtain personal jurisdiction upon the plaintiff serving the defendant in the state in which the court sits, and the defendant needs to voluntarily appear in court. All 93 cases, I never once voluntarily appeared. I appeared because I was coerced and induced, because nobody explained to me the difference between the legal name and myself and how they operate that. Now that I know the difference, I went in and I tried to explain that in simple form, but she just didn't understand it. Now I just have to reiterate it as many times as I need to and just stand firm. I am not the legal name.
I got one of those. I got one of those letters, Keith, and I responded on the back side, and I asked them if they could provide me information about jury nullification. And then I got a letter back that said they're not interested in having me as a juror. That was like 10 years ago.
Well, of course. They don't want
Right.
people that know and have knowledge. They want the dumb people that believe they are, in fact, a United States citizen and will go in there and say, yes, I'm a United States citizen.
Right. Well, I just wanted to find out about if I was qualified or not. So that's why I was asking for the jury nullification, information regarding that. Although I think I know, I asked them to provide that, and then they declined by taking me off.
I can present the plain writing of the laws, as I stated many times. If the states ceded their jurisdiction to the United States, and the United States is known commercially as the debtor, and under the commercial code for debtors, it says the United States is located in Washington, D.C., and the fact that there is no birth registration in the United States for people born in the United States, then no one can actually claim to be a United States citizen. I can nullify a jury by myself, where no jury can be had against me unless they are in fact a jury of my peers in a Article 3 court, recognizing or cognizing their republic form of government for such criminal actions and not some legislated trust law tort claim.
Doesn't the Constitution for the United States say that they are citizens of the United States, not U.S. citizens? I think there's a large distinction and presumption with that, because that bank charter known as the Constitution for the United States, I'm of the opinion that it applies to me if I comprehend it and elect to utilize that. And that
If
says
you elect
that
to utilize
we are
it,
citizens of the United States.
but again, in order to elect to use it, you have to be organized under the laws of the United States at 12 U.S.C. 614, having communications with the Federal Reserve, establishing your intent to be corporate and act as a corporate body. Without that, you don't have a board of directors that can hire an attorney to make a representation of that corporate body in those courts.
Mm-hmm.
Yeah,
That's
see,
right.
this sounds like to me that when we were talking about taxing the road, when you were talking about the taxi driver and that road getting taxed, and it's like the abomination is to build a road over the earth, over the land, and then tax it is like it's still consideration to that enumeration of birth. They built a
Yep.
commercial road right over the person and placed all of those taxes and levies on top onto that road,
Yep.
and just like paved the person over, or not the person, but the Samaritan
Yep.
or the
Absolutely.
child.
Absolutely. And it says in this final section here, it says, whoever violates this section shall be fined under this title, imprisoned not more than 20 years or both. If death results from a violation of this section, or if the violation includes kidnapping, an attempt to kidnap, aggravated sexual abuse, or an attempt to kill, the defendant shall be fined under this title, imprisoned for any term of years or life, or both. So you can get up to 20 years or life for forced labor, guys. 20 years to life for forced labor. I'm not going to play games. I am tired. I'm old. I'm getting wiser, and I have much to share with the future generations, and I don't think people need to be stopping me. The next one, and we're going to look at, is 1702, obstruction of correspondence. Whoever takes any letter, postal card, or package out of any post office or any authorized depository for mail matter, that's the deposit. It's a deposit. It's a deposition. You took it from one position and you placed it in another position. It's a deposition, deposit, depository for mail matter. That is the subject matter. If it goes through the mail, it's a subject to the mail matter. I hope everybody comprehends this. It's all of the government instrumentalities being run through the mail, run in the mail system, or from any letter or mail carrier, or which has been in any post office or authorized depository, or in the custody of any letter or mail carrier before it has been delivered to the person to whom it was directed, with design to obstruct the correspondence or to pry into the business or secrets of another, or opens secrets, or opens, secretes. See that? Secrets and secretes. Embezzles or destroys the same shall be fined under this title or imprisoned not more than 5 years or both. What they're doing is embezzling. They're looking for funds, fines, fees, and penalties under administrative contracts that pose no debt. It doesn't pose a debt because there's supposedly a contract that somebody is subject to, and being subject to it, it poses a fine, fee, or penalty that they already agreed to. So it's not an indebtedness, it's a course of action. And they're playing you as contractors. You're not subject to the statutes. Again, 48 CFR 52.212-5, contract terms and conditions required to implement statutes or executive orders hyphen commercial items or commercial services. So in order for them to implement the state statute for jury duty, they must have a contract with me as a jury member stating that I am a citizen of the United States, a resident, showing that I have a bank account wherein I can fund my own transactions, and I have an income where I've had income transactions where I've invested in ventures. They don't have any of that. None of it. The next one is 1708. Get back here. Which is theft or receipt of stolen mail matter, generally. Theft or receipt of stolen mail matter generally. Whoever steals, takes, or abstracts, or by fraud or deception obtains, or attempts so to obtain from or out of any mail, post office, or station thereof, letterbox, mail receptacle, or any mail route, or other authorized depository for mail matter, or from a letter or mail carrier, any letter, postal card, package, bag, or mail, or abstracts or removes from any such letter, package, bag, or mail, or any article or thing contained therein, or secretes, embezzles, or destroys any such letter, postal card, package, bag, or mail, or any article, thing contained therein, or whoever steals, takes, or abstracts, or by fraud or deception obtains any letter, postal card, contained therein which has been left for collection upon or adjacent to a collection box. That mail matter being deposited is being deposited in a collection box. It is known as a communication, which is a conveyance of a debt or otherwise authorized depository of mail matter. And therefore, when you deposit that communication, you are dispositioning or depositioning the conveyance of the debt. Whoever buys, receives, or conceals or unlawfully has in its possession any letter, postal card, package, bag, or mail, or any article or thing contained therein, which has been so stolen, taken, embezzled, or abstracted, as herein described, knowing the same to have been stolen, taken, embezzled, or abstracted, shall be fined under this title or imprisoned not more than 5 years or both. So anytime they take those data elements from the hospital and they enter it into the mail routing, whether it be physical definitive paper form or electronic routing, period. Either way, those are mail matters. So the public record as an administration record is a mail matter. That is the subject matter, is the mail, which relates to the routing. The next one is 2331. We saw that earlier. 2331 is a section of definitions. International terrorism. National of the United States has the meaning given such term in the section 101(8)(22) of the Immigration and Nationality Act. National of the United States is a conference of a United States citizenship. A vessel of the United States under 18 U.S.C. 9, subject to the 18 U.S.C. 8 obligations and other securities of the United States of the subject territorial jurisdiction, which is 18 U.S.C. 7 special maritime territorial jurisdiction. So the vessels of the United States, known as United States citizens, are obligations and other securities in contract form. That's all it is. The term person means any individual or entity capable of holding a legal or beneficial interest in property. A legal or beneficial interest in the property. I do not hold a legal interest in any property. I hold beneficial interest, and I waive no benefits under God. Period. And you can read this one and go on. It talks about the Immigration Act and terrorism.
So who is qualified to be a custodian of the legal title then, Keith? Maybe you could speak to that for a second.
Well, the one that has custody. Who would the one that has custody be? If the Social Security Administration or people throughout your life told you that at the age of 18 you had to sign up for Social Security so you get a license and a job and everything, that's false. So what happens is at the SS5 application, you send it in, and then they send you a card. You now are in custody. You have in custody, and you are holding that card. Now, is that legal custody or beneficiary custody? Well, the difference is the front side is the legal side for debts, communications, conveyances of debts. The back side is for the credit side. It's the private side as the beneficial use.
So only the trustees, only the trustees can are trained custodians to manage the public side of the card, as it were, the debt side of the
Correct.
card.
And
And then
because
the
we are never trained,
executors of estates would be concerned with the credit or the back side, the private special side of the card.
right, and
with
that's
its
the one
red-
you use to set, and that's the one you would use to do all the settling.
Precisely. And the recent attorney that I talked to, we met him in a private session at his firm, and he did not disagree with when I explained that I was there representing the estate side of things, and that he had no interest in the number on the back side of the card, and he agreed he only needed the information and the confirmation of what's on the front of the
Right,
card.
and the confirmation of the stuff on the front again can implies that it's being operated as a public liability rather than a private credit.
Right. So we appointed the firm to do a Chapter 13, and then when they determine, the claims of the creditors, whatever they might be, whatever's owed, then the executor's office can issue them an international bill of exchange to to settle that.
Yep.
That debt, whatever it is that we that he contracted with, to as a surety to pay that. So I just wanted to speak a little bit to the practical use of the backside of it, and my opinion is that unless we have that knowledge to operate as the executor over the estate, then that responsibility falls upon the representatives and trustees of the state, and so that's not to be used in any way with incompetence by anybody. I just really want to make that a very clear point, because you can be in trouble if you're not having knowledge about how to operate that side of the account.
Yes, and that's why I say I don't want anybody to do this stuff. Do your research. Do not believe me. Do not believe your neighbor. Do not believe the government. Do not believe your mother. Do your research so you can get the comprehension to know how it applies to you or how you can apply it in your situation, and then go forth. Never trust another man's word, not even mine.
Yeah, Jai Ho.
Okay, the next one, we're going to get into a different section of the code as it relates to the money and finance and everything, as it relates to the securities. The securities are a matter of national defense. So under Title 32, National Defense, Department of Defense, Office of the Secretary of Defense, Security, Department of Defense Personnel Security Program. Under this one, 32 CFR 156.1, Purpose. Now, I did a video on this section, and I explained all of these executive orders. These are executive orders. This is 5 USC 301. the statute that I talk about in regards to the enumeration at birth, the departmental regulations, wherein they talk about the Plain Writing Act, the minimum birth registration requirements, and the fact that it applies to the Department of Defense. So the enumeration at birth is the establishment of a personnel of the Department of Defense. The legal name is presumed to be a personnel of the Department of Defense. Again, I was not born in the military. It presents a false record. Consistent with executive orders, 5 U.S.C. 301. And the last one here is HPSD 12. Homeland Security Presidential Directive 12. You'd be surprised. That's the ID. That's that new ID they come out with.
Under the Real ID Act, is that what you mean?
Yep.
By 2025, that's that's supposed to be implemented everywhere with all
Right.
everyone.
And it's Homeland Security Presidential Directive 12, policy for a common identification standard for federal employees and contractors. If you are not a contractor, you are not required to have an ID. And when presenting an ID, you are presumed to be a contractor. You can give the
Presumably subject to the principal that you contracted with.
correct, and that ID has a title on it, and then gives an address, and they use it as a name and address. Wherein you, if you are buying or selling or a ship to party as a benefactor, where the goods are supposed to be shipped to you, you are allowed to give a number in lieu of the name and address. No one's ever taught us about this, yet it exists at 19 CFR 149.3. I went over this the other day. Data elements. Every data element you give them is usable. How do you want to use that? Think about it and start educating yourself. It says here, data elements, shipments, as in United States vessels, citizenship, intended to be entered into the United States, enumeration at birth, and shipments intended to be delivered to a foreign trade zone in the state, because all of the benefits are supposed to go to the state, but they supposedly come from the United States, except as otherwise provided for in paragraph B of this section. The following elements must be provided for each good listed at the 6-digit HTSUS number at the lowest bill of lading level. Anything that's meant to be entered into their docket is a bill of lading. The manufacturer or supplier, country of origin, and commodity HTSUS number must be linked to one another at the line item level. The commodity HTSUS, harmonized tariff system of the United States. Under seller, name and address of the last known entity by whom the goods are sold or agreed to be sold. If the goods are to be imported otherwise than in pursuance of a purchase, the name and address of the owner of goods must be provided. So when they demand the name and address, they're wanting it as an import.
So what's the difference if you give them the number versus the name, and how that is?
If you're importing it, it's
translated?
theirs. If you're importing it, it's theirs. In pursuance of a purchase, it's yours. So the name and address of the owner of goods must be provided. Otherwise,
is that like a consumer credit transaction?
if the goods are to be imported, entered into their jurisdiction. Otherwise than in a pursuance of a purchase, the name and address of the owner of the goods must be provided. Okay. So in a credit transaction, I am not providing the goods. I am not the one that's supposed to give a name and address. I'm in pursuance of a purchase, and a widely recognized commercially accepted identification number for this party may be provided in lieu of the name and address. Now, the seller, what people don't realize is the seller is a reseller. He got the goods after they were imported into the United States. The state claims ownership, and the seller has to retrieve the property or obtain the property from the importer.
Is that why all the goods in the stores are considered legally abandoned and those stores are
Correct.
warehouses?
Correct. And they give you warehouse receipts, and those warehouse receipts, every last one of them says U.S. debit. Okay. And if you're a buyer, the same thing. A widely recognized, commercially accepted identification number for this party may be provided in lieu of the name and address. Ship to party. The party as the benefactor, the beneficiary receiving it. Name and address of the first delivered party scheduled to physically receive the goods after the goods have been released from customs custody. Customs custody. That warehouse.
That's after they go through the Panama Canal.
Hold on. That warehouse you just spoke of, those stores are in custody of customs regulations all the way up from import of the United States. It had to be imported in the United States, and they hold it in that local warehouse, and they are the ship to party. Name and address of the first party deliver to parties scheduled to physically receive the goods after they have been released from customs custody. They are still in customs custody as a warehouse at the local store. Once they have been released from them to you, you are the ship to party. It was shipped to them, but you are the party that received that the goods have been released from custody to.
So is it at the Panama Canal where the United States takes what it needs for the military and then the rest of the goods are abandoned going to those warehouses?
Yep.
Is that how that operates?
I believe so. I believe so.
I have a question.
It's all a matter of importing the documentation and then having internal documentation that matches up. This is why they need that enumeration at birth and mom to sign that document. Go ahead, brother.
Okay, that's my question, because my question is, we're talking about warehouses and stuff, and so the gist that I'm getting is, so that enumeration at birth abandoned us into the warehouse of a corporation. So whatever state that we could be in at the time there, we're asked for an ID of being an import. Like if I'm going to a different state, then they're going to take whatever commercial monetary value from my infraction as a it's like a custom thing. It's going to be a receivership then of asking for my name or my ID instead of the number. So I'm just basically the enumeration of birth made us abandoned property within this corporation. We're actually abandoned property until somebody lays a claim on us or something.
Right,
well,
and that's the way the mail.
It's not the men and women that are abandoned. It's our interest in the vessel that they claimed at the hospital, known as placenta. Right, that's the estate. That that's the corpus that's tied to the estate that owes the taxes. Right.
Well,
it's not the men and women, in as much as the concept of them accepting that placenta into their warehouse, as it were, in
I
the
don't,
record.
I don't want to conflate anything, so I don't refer to that kind of stuff. But I will say it's the interest of the beneficiary. That's what's abandoned, is the interest of the beneficiary.
Sure. It's the placenta should be taken and put back into the earth, but they take it and they put it in some storage facility, and then and it's cooled, and then it it basically dies slowly, and this is what they're calling a decedent estate.
So the
And
enumeration at birth, abandoned the interest to the beneficiary, and then at 18, when they told you to get the Social Security card, they misplaced you as a trustee. That then they taught you to be a trustee over that abandoned beneficiary, and you're operating it all wrong, which puts you under all these laws that make it criminal for you to go down the roadway or whatever, and they can find all these criminal things wrong with what you're doing because
it's improper use of that Social Security. If you ever got the card in the mail, there's
you're the
a
trustee
notice
acting
right on
like.
the front that says improper use, and
But
it
it
leads
makes
to
you the trustee.
imprisonment, fines.
But wait a minute. It makes you the trustee of your own beneficiary, but you're not. It's almost like that's an impossibility to that fact. That
No,
It's
it's
a
not. It's not an
co-trustee.
impossibility. What it
It's
is
it's a co-trustee position, that more so.
yeah, it's not an impossibility. What it is it's a lack of training, lack of education of what you can do. And the way I state it is, if you're traveling down the road and you get in an accident, the state claims the ownership by that title, right? That title is a beneficiary record. The state maintains that interest in that beneficiary record. And if you get in an accident, you're presumed carrying that ID to be a trustee. And now what you've done is you've just destroyed property that belongs to the beneficiary. Okay. As a trustee, you are due to the beneficiary now. If you don't recognize the beneficiary as the record and yourself as the benefactor and how to place the gifts to yourself, then somebody else is always going to claim that interest. And that's what happens at the enumeration at birth. There's an establishment of a legal estate that the state has an interest in, presumably. When age of 18 reaches and you go out upon the world as an adult and you want to start conducting business affairs, you can either use the legal identification that the state gave you, or you can collapse that trust for what it is, a public trust, and operate privately and do your commercial transactions as a private trustee under your own private trust, gaining benefit as benefactor to your own private trust.
right, but
You
you
can
have
play
to
all
collapse the
positions.
public. You have to
Right.
collapse that public one. That's why I said it seems like it's an impossibility. Because, like you said, it's not an impossibility. But if I was out on the road and I had that card, I would be destroying my own property, which would put me in indebtedness to myself. That's why I kind of claim it seems like it's an impossibility to do that, to be public, to be a trustee public and be a beneficiary privately, as in you destroy yourself. You're destroying
Correct.
everything that you're a
And that's
Yeah,
beneficiary.
they just give us the opportunity to destroy ourselves through, laziness, and that's
And
how it's
again, I've
always
got to
been.
remind
Through
everybody.
their education, we've destroying ourselves through that education. Like Keith would say that same thing. Lack of knowledge is the destruction of the people. Or the yeah. They
And
Yeah,
that's
teach
and
and
us to
more
destroy
specifically,
ourselves.
incorrect knowledge is knowledge in the
right.
mode of ignorance. It's incorrect
And
knowledge. It's what we've been fed.
I've got to say, as much as I was indoctrinated, as smart as I believe I am, and as smart as I believe other people are, many people, even these officials, are still indoctrinated and don't know these truths. They don't comprehend this much as much as some of us do. And that's why it's important for us to go out and start asserting this and doing that correction stuff. Now the next one, 32 CFR 156.2 applicability. Again, the National Defense Subchapter F Security Personnel Security Program. As I mentioned in the last one, 5 USC 301 departmental regulations, they talk about that enumeration at birth, minimum birth registration requirements, the plain writing, and the fact that it is applicable to the Department of Defense. And here again, it states it again, applicability. This part applies to the Office of the Secretary of Defense, the military departments, the Office of the Chairman of the Joint Chiefs of Staff and the Joint Staff, the combatant commands, the Office of the Inspector General of the Defense, the defense agencies, the Department of Defense field activities, and all other organizational entities within the Department of Defense. The legal name is an organizational entity that was never properly organized under the laws and contracting with the Federal Reserve so that they could operate with a trust, with a board of members or board of trustees that could hire an attorney.
It was created in the form of a sole proprietorship, but that was never it was never properly
developed.
Developed,
It never
right?
developed into a proper corporate entity. Never happened, and they cannot see. That's why they say that you have to be represented by an attorney in those courts. Under Texas Rule Civil Procedures 12, even if you own the company, you cannot represent you cannot represent yourself in court, and you cannot hire an attorney to represent you in court. It is a decision that must go through the corporate's board of directors. They have to make a determination whether it's worthy to file a suit or fend a suit. If not,
unless of course we got a small claims court, I think we can, if we're not organized, we can do something in small claims court. Is that
those
correct?
are not those are small claims courts. They're not administrative courts. In the
And attorneys can't really enter in there, from my understanding.
In administrative courts. I just lost it.
Can you? What'd you lose?
I just lost my final thought that I was trying to get out before you interrupted me.
I apologize. Forgive me.
The board of directors under Federal Rules of Civil Procedure in Texas, the only ones that can hire an attorney to represent you in court is a board of directors. Having a board of directors means you must have a trust set up as a corporate organization under the Federal Reserve so that you can promulgate the issuance or the delivery or receivership of those various different documents through the mails. If you do not have that, then you're not qualified to even appear in those courts as a defendant.
Correct.
You can't hire an attorney through a board of directors. So they say, well, we'll appoint one for you. That's because they're using their board of directors to hire an attorney to represent you as if though you are part of that corporate entity, and you're not.
Right, like the Temple Bar. The Temple Bar has its own boards of directors, and then they're those entities they're appointing different attorneys or members of their private member association to do the administration. Right? Is that what you're speaking to?
Exactly.
And they have an oath to, the bar has an oath to the Constitution, in my understanding, right?
Yep. And then the next one. (32 CFR 156.3 National Defense Department of Defense Office of the Secretary, Subchapter F Secretary, Part 156 Department of Defense Personnel Security Program is a policy. It is not a law. It is a policy. It is a corporate policy for those that are subject to that corporation. In other words, you have to be a member. You have to be a direct associate. And it has to do with Intelligence Community Directive 704. What is your intelligence level? This is where they're taking advantage of everybody through the General Public Education Provisions Act. It's a military education, and they're only going to educate you enough so that you can perform certain functions without clarity. Because if you have the intelligence, you will collapse that public trust as it is, remainder all of those, or revert all the remainder credits as a remainder man in a resurrection under a merger in a new name. It is scriptural. My people are destroyed for lack of knowledge. That legal trust is a false trust. It is a definition.
So if we get a new name, would that not be a nation that would require a treaty to act?
No, you just need a new name. You do not have to act as a nation. Again, we're prophets unto the nations. The nations use documentation to prove their existence. We use our physical.
Well, I'm saying to interact with the entity after you do to interact with the world. It would seem to me, and thinking
you're
that
just setting up that private trust account with the postal enterprise payment system.
Okay, that makes sense.
Department of Defense personnel security program policies and procedures shall be aligned using consistent standards to the extent possible. Provide for reciprocal recognition of existing investigations and adjudications. Investigations. I'm vested in the full armor of God. And as far as I know, that full armor of God, according to the breastplate of armor, has 12 gems. Do you know the value of those 12 gems? I'm going to say I have 12 talents, and each talent is worth 75 pounds of gold. That's a little over $1 million for each of my talents. Would you like to experience them? Which ones would you like to experience? It's very important to learn your talents, folks. I'm going to stop the screen share now. We're going to end this session for a little bit. We got a little bit more to go. We're going to go, but I'm going to end it here in a little bit so I can go grab a bite to eat, and then we'll come back about an hour later. So anybody that's here now, you want to continue on, please come back. But what we're talking about here is definitely the intelligence of people and how we can expand that. Again, it's not a matter of asserting any kind of accusations or anything, but rather realizing everybody else has been duped just as much as I have. And therefore, I have to give them that same leeway that if I was in their shoes still, that I would hope somebody would give me the leniency to take upon the time to learn like I have in the last 7 years. If I'd have had that time to learn back in my younger days, if my parents had been allowed to teach me that in my younger days, instead of being induced into a public education system saying that you have to send your kids to that school and you have to follow that curriculum, that's false too. You do not have to send your children to these public schools. You do not have to follow their curriculum. You can supersede their curriculum. Their curriculum is so easy to supersede. And that's all you got to do is show them that you have a superior knowledge. You're not saying you're smarter than them. You're not saying you're better than them. You're not going to accuse them of doing something wrong. You're coming to peace with the fact that, hey, maybe I'm not as smart as I thought I used to be, but I'm getting there. And in knowing that, maybe he's not as smart as he's professing to be as he sits on that bench. If I go to him peacefully and give him certain data elements, he might find a new path. Now, I don't expect him to find a new path for himself, but I do expect him to see the path that I'm on. And though it might seem a hard one, it's the only one I see. Don't offer me any other fictitious paths. Don't offer me any other fictitious mail routes. I'm not going to follow them. I'm going to go through them. What do you got, Russ? We ain't heard from you for a while. You fall asleep? What's going on?
No, I've been sitting here taking my notes. Yeah, then I actually had a phone call. I'm surprised I was still on here about 15 minutes ago from that brother down there in El Paso. Hemmed up in the who's
Hey,
gal.
Iman El Bay join us here. I see on the board. Greetings, brother El Bay.
So you say you're going to cut it and get you something to eat and come back in about an hour?
Yep, I think so. So I'll see everybody right around 6 o'clock. If anybody's got anything else to say it now, and then we'll take our break. Otherwise, I certainly appreciate everybody's support. Please keep at it. Please keep informing yourself of better and superior facts. They are out there. I will do everything in my power to show you where they're at. But please, again, I remind you, do not believe me. Do not believe the government. Do not believe your neighbor. Do not believe your mother. Quit with the belief stuff and start learning how to know. This is knowing our Father, which art in heaven, knowing our mother, which we're supposed to observe her laws according to his instruction, and we are to know ourselves and our place in that.
I just wanted to add what you had said just a little bit ago, which is, regarding the public school system, and we don't have any feeling to devalue that, and it does have its value to keep the world going. But I feel that if our education stops there, then we're really kind of not doing anything good for ourselves. So
absolutely, and I'm not trying to say that you have to dismiss the public education system, but if you're going to get involved with it, make sure you're aware of the paperwork and the documentation, how to endorse that, as well as make sure that you go above and beyond their curriculum. I was in a situation that once I was adopted, I still went to the public school, of course, but the parents that I had also educated me at home as it related to other things, gardening. We had our own little library of all the National Geographics, Britannica library, all the encyclopedias and everything. So I could do a deeper research on things. And they actually sat down and helped me with things. And that's the homeschooling mixed with the primary education is a great thing. You can still do it that way. But again, I urge you that if you're going to be doing that public education, make sure you're aware of the terms and conditions they're placing, and that you always assert you are the superior. You are the superior, and they are the trustee. You are the grantor. Your child is the benefactor. You're giving the education to your child. They are the beneficiary, and the school is the trustee. If they deny that trust, they're in serious trouble if it comes against somebody like me. That's the bastardization of a child, is the language that they're teaching in those schools. Now, if you want to teach those children that language in the schools, again, that's fine, because we're supposed to know their tongues. But when you bring them home, help them with the realization of exactly what concise English is, so that when they do their homework assignments and stuff, they will get those grade A grades and stuff, and they will be at the top of their class. Hopefully someday there will be a portion of the class that will be seen as the top of the class, that will be so innumerous that the United States, again, will be number one in education around the world rather than 43rd. See, when I was growing up, America was number one in education, and that was less than 50 years ago. We've fallen to 43rd.
I just wanted to share with the group here that an interesting and cute experience I had talking to my son on the phone. over the last week or so. He his birthday is coming up in November. I'm going to go visit him, but he asked me, "Hey, Papa, do you have any money?" And I said, "Well, I do. What kind of money do you want?" Right? And I explained the different types of money that they are. And his mom wrote all that down. And then I talked to him the other day, and he told me what kind of money he wants, which is he wants the money in gold coins. So I went and I took I took some funds that were contributed, and I went down to the Enterprise Bank and bought the $25 coin rolls, because those are nice gold coins. And so I'm going to give him a few of those for his birthday to save. Right, put in his But at first, I didn't just say, "Well, yes, I can give you money." Right, I caused him to think, what kind of money does he want? Right. I told him, "Do you want checkbook money? Do you want a bond? What, you know?" And right, and his mom helped him make that decision, what kind of money he wants. Right, and
There you go.
so I'm going to give him 75 of those gold dollars, and have him put them in his own express trust that I helped him create. So, even with the young people, you can, cause them to think and be rational, and say what they want, right? Like, that's not necessarily something that other people learn, right? That there's different types of money. And, that's not something that's taught to young people usually, right?
Yeah, that's an important element to realize that even this, little notepad, that's
right.
Potential money. That is potential money. I can create money out of a note.
Right.
All right.
Well, I'll give my son pretty much whatever he wants or whatever he asks for, but he has to ask specifically for what he wants and why he wants it, because he's the beneficiary. He has to be knowledgeable as to what actually benefits him, right? And be able to speak to that, right? So how our trust is set up. So I'll give him money on his birthday, the kind of money that he asked for. And, if he asks me next year, I'll give him more. Right. And then we hope that he'll learn how to invest that and make that, and, grow into something.
Absolutely.
That
you're doing a great
him.
job, brother. You keep in touch with me on your communications with the local officials and stuff too. Be sure to do that.
Right. I'm going to go meet the senator in a couple of weeks here. I made an appointment, and just have a conversation with him, the local senator. Try to discover how I might be of help to them in our local area here.
Awesome.
Yeah.
You need to do
I'll
that.
keep you posted on that.
All right. Well, we're out, folks. Like I said, we'll be back in about an hour. So be watching for it. We'll do another 4, 5, 6 hours, whatever allows for us tonight. And then whatever material that we still have left, we'll do again tomorrow. So we'll go for about another 4, 5, 6 hours tonight in about an hour. So I'll be back. In the meantime, God bless. I love you. I don't give a rat's ass whether you love me back. So have a good time, and we'll see you again shortly.
See you soon.
Bye now.